Yes.
May I please alert? My lord, a cooperative matter, my lord.
Huh?
My lord, a cooperative matter, my lord. I was wrongly removed. I filed the writ petition yesterday. Let it be listed tomorrow, my lord.
What is there? What are you challenging?
My lord, challenging the order of the registrar, my lord. I was removed
As a
from the post of chairman, my lord. Wrong interpretation of the bylaws, my lord.
tomorrow.
Tomorrow, deeply
You have
obliged.
filed it,
Filed it.
subject to clearance of defense.
May I please, Your Lordship?
Yes.
I beg to mention for my lord, bringing on record one affidavit in reply filed in item number 9, my lord, today. That is filed, my lord.
Filed by you.
Yes, ma'am.
When?
Today, my lord.
So let it come up on some other day.
My lord, matter is fixed today.
Huh?
Today's matter is fixed.
Fixed. Why did you file it today? If you know it was fixed today, why have you filed it today morning?
Yes. My lord,
We'll have to look into it. We'll look into the files.
Lords,
Let it come up next week.
Lords. My lord,
11.
Lords,
Item 9 be listed on 11. You are appearing for
writ petition on my
writ petitioner. As the counsel for the petitioner, Mr. J.M.A. Chaudhary, submits that an affidavit in reply has been filed today during the course of the day. Today morning. Stop registry to connect the said affidavit filed and list the matter again on 11th.
I'll inform the other side, my lord.
Please inform me.
May I please alert? My lord, I beg to mention for listing of two motion matters. Friday, my lord. Motion matter, my lord.
Motion for what?
Motion, my one is land acquisition matter. And another.
Press matters.
Rest matter.
All right. Friday.
May it please, Your Lordship. I beg to mention an writ petition, my lord, list filed yesterday, Lordship, for as unlisted, my lordship. And the matter pertains to my lord illegally constitution of a my lord pharmacy council, my lord, without following the my lord election rule, my lord.
When
And
did you file it?
yesterday we filed, my lord.
Tomorrow.
Tomorrow is the date for my lord first my lord meeting, lordship.
No,
So-
let it be. Doesn't matter. When was it constituted?
My lord, constitution sometime ago, my lord, but notification is published yesterday, lordship, for first meeting, lordship. So may I take an up as unlisted today, lordship?
Today, let it be tomorrow. Tomorrow morning, 10:30.
Obliged, lordship.
Met please, back to mention for listing of contempt matter, lordship. Respondent has already entered appearance, lordship, on 8th of January 2086, lordship. So matter may kindly be taken up.
16th February. Yes.
Lordship, I pray for listing of a matter for admission. It was,
Admission. What is the matter?
Lordship, it relates to election of a Gao Panchayat president.
Admission matters. So 17th,
Little before that.
17th February.
Can it be on 13th, your lord?
No. You said admission matter. Pleadings are complete.
Pleadings.
17th. Yes.
May it please, Your Lordship, I beg to mention writ petition before this honorable court. Fresh matter may be listed in motion. There is a urgency in this. It is related to violation of Article 21
Or what? Why?
of the Constitution.
No, I know of the Constitution, but why is it violating? What happened?
Your Honor, the petitioners, they had applied for registration of marriage under the Special Marriage Act, but the concerned authorities have not accepted their application because they profess different religions. So already 2 months have passed, my application has not been
Let
accepted.
it be on Friday.
Friday.
Yes.
Obliged.
May it please, Your Lordship, I beg to mention item number 1 of daily list. Kindly pass over it for a
Oh,
date.
you wait. Item 1 will come just now. Wait for the matter to be called up.
May I please, your lordship? So I'm praying for listing a writ petition, lordship. Matter is pertains to Panchayat election, lordship, of president. But president was elected by the boards of disqualified
You are
members.
praying for a
Motion, lord.
motion matter,
1/5, lordship.
not 5th, 6th.
Yes, lordship. And another matter is, lordship, admission. Matter is land acquisition, regarding land acquisition, lordship.
17th
Lordship, period 17.
of February. 17th
Plus-
February. Yes.
May it please, Your Lordship. Lordship, I beg to mention for listing of a writ petition, Lordship, for admission.
Admission 17th February.
Obliged, Lordship.
May it please your lordship, I beg to mention for listing one matter lordship. Matter relates to land acquisition lordship, admission matter lordship.
Admission matter, 17.
Oblige lordship.
May I please, your lordship, with the concern of the other side, I beg to mention item number 2, your lordship.
Why?
Lordship, my senior has some personal difficulty today, lordship, may kindly be taken up after a week, lordship.
When is the other matter fixed?
Lordship, 19th.
19. We'll have it on 19.
Highly obliged, lordship.
19.
Interim may kindly continue, lordship.
Yeah, we don't know. Whatever is there is there. Continue. Yes. Yes. Any instructions here?
Other day, Mr. Mr. Chawat, yes, he submitted the appellate provisions, your lordship. Where can, the petitioner can prepare an appeal. And since these two matters are similarly situated, lordship,
Okay, two
they
matter,
paid for
second
taking
matter.
up this matter together.
Under section 111, your lordship, appeal or review, subsection 3, the appeal lie before the state government, your lordship.
Cooperative. Cooperative matter.
Lordship.
Cooperative society said.
On last occasion, your lordship, my senior has already stated about it.
Section 35.
Bundle to apna. Second.
Yes.
On last occasion, your lordship, my senior has already stated about it, that the appeal shall lie before the state government, your lordship. That is appeal and review, section 111, subsection 3, your lordship.
Why will it lie to the state government?
My lord, they have
This is an
filed
order passed by whom?
registrar, your lordship.
Additional register.
Additional
page
register, page
48.
48.
lordship.
Page number
Page
48.
48.
48. In which writ petition?
380 2026. 380 2026.
48, yes.
And the additional register is equivalent to the register, your lordship, and they have filed the appeal to the register in page number 50, your lordship.
Additional registers orders are appealable to the state government, not to the registrar.
No, your lordship.
Why?
Additional register and register are equivalent by your lordship. There is a notification, your lordship,
Where is that?
that notification I have not annexed, your lordship, but it is equivalent that the additional register has conferred all the power of a
You
register.
show us from the- get the-
My lord, section 3, your lordship,
Hmm.
may come to section 3.
No, where is the notification? Get the notification. We'll take it up after a while. You get
Okay,
it.
your lordship, I'll get the notification.
Let it be complete. After a while. Why was it mentioned before a division bench?
My lord, sorry, my lord, that I thought, my lord, that because some the documents of Services Act was annexed, that is why, my lord. It comes to single bench, my lord, I'm sorry. My lord, it is regarding restriking, huh?
May I please your lordship, Mr. Sharma is legs before another court. May kindly pass over the matter for the time being.
You take permission of the senior counsel on the other side.
Oh, it come.
Yeah.
My lord, here, we are not on the surface, my lord, action. Here, my lord,
You are an MSME
MSME. MSME, my lord,
and there is a circular
circular is there.
for
My lord,
restructuring.
Yes, for restructuring. Here, my lord, what happened? They have considered a old circular 16 circular was up to 25 crore. But the present circular, if you also see at page 110, This is up to 2,000 crore, 20 billion,
Page number?
page number 110. At page 113. This is the subsequent circular to 19.
110.
110.
Yes.
At page 113.
113.
This circular is, my lord, even 20 billion above pair 12.
Page 113 is para 14.
Pair 12.
Para 12.
At page 113.
Para 12 is 112.
112.
That is you are referring to the chart.
Oh, chart, my lord. Chart.
Great.
That is, here said aggregate exposure 20 billion and above, 15 billion and above, but less than 20 billion, then less than 15 billion. My lord, these are the, my lord, and restructuring formula is there, my lord, at page 119. Prudential norms applicable for this restructuring. One on eight. 118, my lord. At page 118, that is the prudential norms applicable for restructuring.
Hmm.
So these are the, my lord, mandatory guidelines. Supreme Court has time and again said, my lord, that these are the mandatory guidelines and they are to follow. Latest judgment of the Supreme Court is also there, my lord. That it says that, my lord, that this is a mandatory guideline.
What is it? What is the judgment?
Just time. Earlier judgments are also there.
Because pro needs, yes.
This judgment, my lord,
That this guideline is mandatory.
mandatory. And para 42, if you have see, if in the terms of the guidelines issued by Reserve Bank of India at page 271, a right is created to a borrower. We see no reason why writ of mandamus could not be issued. We should assume that there is contestation.
Paragraph?
Paragraph 42.
42.
Para 38, they said, my lord, this is Reserve Bank of India. 38 and 40.
You are referring to pro needs.
My lord,
Pro needs.
pro needs.
It doesn't contain that many paragraphs.
Sorry. I'm sorry, my lord. I've given different. Right. It can be there certainly. Sorry. My lord, at para 16, 15, 16, my lord.
Para 15, 16.
Yes. Section 21 and 35A of the said empower Reserve Bank of India to frame
17.
the policy and give direction to a banking company in relation to the advance followed by the banking companies. Such direction have got to be read in supplement of provisions of the Banking Regulation Act and accordingly are required to be construed as having statutory force and mandatory. My lord. And the other observations are also there, my lord. So, the High Court judgment has been set aside. High Court said that it is not mandatory. And
Yes.
here, what happened, my lord? We have submitted the restructuring formula, and they have
The-
issued a letter.
The restructuring formula or suggestions are to be offered by the bank only. No.
No, my
But
lord,
if-
that party has to submit.
Okay.
The party we have submitted, my lord,
Hmm.
and that restructuring proposal. If you also see, my lord, that the well, proposal is at page 234. The detailed restructuring proposal is there, my lord, because there is some stress due to the blockage of the fund in the government departments, my lord. It is loading, my lord, the industry otherwise.
So you have also enclosed the judgment here.
Yes, oh, yes, that is a. Yes. But now bank has, my lord, issued a single letter, page 422.
Where is the
421.
proposal submitted?
At page 234, my lord. 234. 1126. Prior to that, we have submitted letters, my lord, that we are MSCV, we are submitting the recycling.
Need hum look करें.
And now bank, my lord, did not consider virtually, my lord, now the general manager has informed us verbally that since on the basis of 2016, 25 crore was the outer limit, they have rejected for that now only. Page
They did
422.
not, they did not take into consideration
Yes.
the revised. limit.
No, 2019,
So where is the rejection letter?
that is page 422. One sentence. Last. In reference to your restricted proposal, in the account of Nikon Power and a joint tender meeting was conducted on 16/1/25, where it was unanimously decided that all banks not to proceed with the restricting of your account. Hence, no reason. My lord. This is why, my lord, I am submitting, my lord, we have submitted a second proposal also, later on. 424, we have submitted another proposal. 422. 422. 424. Another proposal we have submitted along with other.
Yes.
So they should consider it, my lord, and they should call us, my lord, there should be a joint meeting and they should consider it, my lord, because stress is there due to, my lord, and they have included these bank guarantee, my lord, not a single bank guarantee has been invoked because all are now, works are over. This is, my lord,
Why there are two banks involved?
4 banks, my lord.
Four banks.
4 banks, because it is joint, my lord, Indian Bank is the lead bank.
No, what, how does it work? How does this scheme
My
work?
lord, so,
Your lordship, it's a consortium.
consortium.
So
Consortium of the banks.
Bank.
yes, sometimes the big companies has been making us a proposal. So it is not possible and feasible at the end of the one bank. So they formed the consortium and accordingly funding was.
Actually, 3 banks, my lord, 1 bank has nothing to, Bank of Baroda, but only 3 banks are mainly, my lord.
So Indian Bank, PNB and Canara.
Canara Bank
Canara Bank, these are the
and
3
Bank
banks.
of Baroda.
Bank of Baroda, my lord, very small, negligible.
So you represent all the banks?
Yes, I am representing Indian Bank and Canara Bank and
Respondent number 2, I am Punjab National Bank.
And who's for 4?
Bank of Baroda is.
4, my lord, nobody is there, my lord. Actually.
So
Your
what do you have to say?
Yes, your lordship, one small submissions only, that the account has been declared NPA in the year of 2025, that is the last year, in the month of June 2025. And your lordship, that the Pronit judgment has already been interfered with by the latest judgment, your lordship. That is,
Subsequent judgments.
yes, sir.
Subsequent judgment.
Yes, subsequent judgment. That is 28th of July 2025.
Yes, very.
Para 6 to 8 is relevant, your lordship. That is, the account has been declared NPA and all the proposals that has been made, that is only after that, your lordship. So after initiating of the section 13(2), they have only remedy left with before the DRT only, your lordship, at the appropriate stage.
Have you gone through the judgment, Mr. Sahiwala?
Well, I don't think, my lord, because proposal, my lord, that scheme does not say that, man. That says it.
And it is also mentioned about Pronit judgment as para 8, your lordship.
Yes, para 8, your lordship. Issue of the coordinated notification is binding to the lending bank secured creditors, finding to the contrary High Court Bombay judgment or order challenge in the appeal was just passed. So while stating the term of framework need to be followed by the lending banks secured creditors before a court account of an MSCB is classified NPA, this decision is also states on the obligation of MSCB to holding that it will be equally incumbent on the part of MSCB concerned, vigilant enough to follow the process laid down in the state framework and bring to a notice of the banks producing authenticated and verifiable document that show the eligibility to get the said framework. It is calculated if such enterprise allows the entire process of enforcement security surfaces to be over. Well, it is not over. Surfaces to be over or having challenged such action bank creditor concerned the court of law or tribunal having failed an enterprise would not be permitted to misuse the process of law thwarting action under SARFAESI Act by raising the plea of MSME at a belated stage. My lord, here,
This should be
they have
very
not
vague.
taken possession of the any property, my lord. The decision, however, left unsaid something which we have explained here now, while considering the terms consciously to prevent undermining the right of the one of the central government confers another. No case for solution, my lord. This is that. So that not say, my lord, that if SARFAESI action is over, my lord, it cannot be done. If they have taken the properties and sold it, my lord, that cannot be done. They are not considered at all, my lord. Let them produce the reason why they have rejected it. Yes, after 32 also, my lord, it can be done. There are 6 last persons.
Already filed for children.
Your lordship got it, my lord?
And
Is
your
I-
lordship, Canara Bank has already filed an original application before the DRT also under
That's
section.
another aspect. That the bank says that is wrongly. Yes. The head office does not know.
Provisions of 32 years. Recognizes that the bank is under the advanced stage. That was. Presentation with the representation will is not discussed. Presentation with the
Your lordship.
This is not really deferred,
Yes.
not set aside.
Not so much.
The ratio of the subsequent judgment is that when it is an MSME and there's a notice issued by the bank, assuming that the bank is not aware it is an MSME, it is for the borrower MSME to bring it to the notice that you are an MSME and therefore you are protected or you are claiming the benefits under the framework,
Yes,
and you submit.
yes, sir.
If you do that, bank is required to consider it.
Yes, that
Yes,
is.
sir.
In the case in this subsequent, this writ petition,
Your lordship, here is they have.
here is a case where they did not approach the bank to say that it is an MSME and it is this framework is available. They waited. the matter was declared to be NPA and sent and interest was levied, only then they came before the High Court, seeking, before the Supreme Court under 32 of quashing. That is what the petitioner, the Supreme Court said, that this kind of
Here is the same-
approach is not acceptable.
Yes, Your Lordship. The same
And then
case
in
is here,
fact,
Your
the
Lordship.
Supreme Court has categorically said that bona fides of the petitioner are in doubt.
Yes, Your Lordship. The same case is here, Your Lordship.
Why?
No.
Yes, Your
After
Lordship.
this-
I am coming, Your Lordship, in
After
chronological order.
notice, my lord, we have submitted application.
Okay, okay.
Your Lordship.
Your lordship, just my lord, before, I still submit. My lord, page 223. my lord.
Oh, yeah. You are right. Checking to notice now.
23.
Yeah, page number 202. 2570.
Because 13 notice has been issued at that time. I know especially said, my lord.
Why do you say?
Yes, Your Lordship. That is, we have issued them the 13-2 notice on 30/6/2025. Thereafter, they have in 60 days time to reply it. So even if they are coming under this 13-3 reply, then it would be considered. But they have come up only with the proposal in the month of January 2026. That is just before the filing of this instant writ petition, Your Lordship. That is why that creates a doubt on the bona fide. It is not that they should have to be vigilant regarding their rights. Now they are sleeping on their rights, Your Lordship.
When was it declared NPA?
Yes, it is in the month of June 2025, Your Lordship.
And the proposal?
And proposal was given in the month of January 2026, Your Lordship.
How many years?
It is 6 months, Your Lordship.
No. How many years after the loan was secured? How many years after it was declared?
Yes, Your Lordship. That is,
It is around 22 years. 22 years.
and the
Huh?
22 years.
After getting the loan,
Yes.
22 years.
Yes, 22 years. It was a consortium finance and first loan.
No. This
latest
MSME,
sanction is on 8/1.
MSME took the loan when?
It is in the year 2003. by way of
2003.
2003 by way of consortium finance.
Okay.
And it was renewed from time to time. And last renewal was in the year 2025.
8/1/2025.
So,
Last renewal.
so therefore, how do you say the bona fides are in doubt? Because
Yes, Your Lordship.
from 2008, they have been continuing.
Your Lordship, I may say.
This is the
that
first time
the-
it was declared NPA.
Yes, Your Lordship. It is always be a first time, Your Lordship. There cannot be a second NPA, Your
naturally.
Lordship. Your Lordship, that is on 8/1/2025, a new sanction was given. That means the terms has been renewed. Thereafter, all of a sudden, in the month of June 2025, the accounts has been declared NPA. That means account declared NPA, that means there is a 90 days gapping.
That's all right. Why don't you examine the proposal which are given?
Your Lordship, that
You
is,
examine it
yes, Your Lordship, I
and come
think it
back
is
and tell us
examined.
that these
Yes.
proposals are on whatever reasons, even if you come to a finding that the bona fides are in doubt,
Yes.
give your proper finding on that. But for a business which has been there for 22 years,
Yes, we are also not against the business, Your Lordship.
no,
Because it is the
You say
objective of
that
the government of
they
India
took
now.
a time of 6 months to give a proposal.
Yes.
That's a business going on for 22 years.
Yes,
Just
sir.
imagine, they are giving a proposal for reconstitution of the business,
Yes, Your Lordship. That is the doubtful point.
removing the incident stress.
As to what was happened in 6 months, that the account has been fallen in such a manner.
Your Lordship, it is not only the 6 months.
Uh,
Though the loan was sanctioned in the year 2003, during COVID, it was restructured by way of GECL loan and so many loans were given to them. So loan were restructured during those periods.
So is it a case that till June, there was a default, continuous default?
Yes,
Yes,
for
Your
the 3 months default, Your Lordship.
No, continuous
That is
6 months.
for getting the account NPA, Your Lordship, there is in guideline that it has to be in default for 90 days
Uh,
preceding the declaration of the NPA. It is not that on the very day we have declared the NPA.
No, but to straight away reject it
No,
without
I think your
giving the
lordship is
reasons
not
as to-
straight away rejected that
Ah.
regarding that I have to take the instruction
you
because
take
only
a-
yesterday I have got up with.
you get your instructions and examine the proposal and see if it is workable.
Yes, your lordship may kindly, this matter may be taken up on tomorrow, your lordship. You take the instructions appropriately.
We do it tomorrow or tomorrow.
I shall not be here, my lord, tomorrow, my lord.
Huh?
I shall be out of station for today.
Your assistant counsel will be there now or on Friday. Friday is all right for you?
Yes,
We'll have it on Friday then.
We are here.
Heard learned counsel for the parties. The petitioner is an MSME enterprise and has established a business of execution of large-scale engineering, procurement and construction projects, including infrastructure, civil and allied works across states in the Northeast. It also engaged in manufacturing of electrical equipments, including electronic and electrical wires and cables. Stop. The petitioner MSME enterprise undertook a loan from a consortium of banks, of which the lead bank is the respondent number one, the Indian Bank. And the consortium comprised, besides the Indian Bank, the Punjab National Bank, Canara Bank, and Bank of Baroda, who are arrayed as respondents 2, 3, and 4 respectively. The petitioner's account was declared NPA because of default for more than 90 days. And it is the claim of the petitioner that the restructuring proposal, which was submitted by the petitioner, stood rejected by the bank without any reasons. Stop. A subsequent proposal pursuant to the rejection of the proposal by the bank has also been submitted, which is yet to be considered by the bank. Stop. Learned counsel for the petitioner has referred to the
(109).
Prudential framework of resolution of stressed assets, which is a set of directions issued by the Reserve Bank of India in the year 2019. These provisions of directions are applied to scheduled commercial banks besides such other entities mentioned therein. And there is a special provision for restructuring of the stressed assets in cases of MSME enterprises. So the learned counsel for the petitioner has referred to the clause 12 of the said guidelines, framework, where it says that the guidelines will be applicable for loans amounting to rupees 20 billion and above. Stop. It is submitted that in so far as the loan undertaken by the petitioner is concerned, the same is covered by these framework published by the Reserve Bank. Stop. Learned senior counsel has referred to the said framework to submit the detailed steps laid out for restructuring of the restructure proposal that is required to be submitted by the MSME. And once it is done, the banks are required to consider the same and make attempts to restructure the account of the MSME enterprise so that proceedings under SARFAESI need not be resorted to. Stop. The Learned Senior Counsel has referred to a judgment of the Apex Court rendered in pro NITS versus so-and-so reported in 2024 10 SCC 292. Referring to para 42, referring to
15.
para
There are 15.
15 to 22, the Learned Senior Counsel submits that the judgment of the Apex Court dealt with the same set of directions issued by the Reserve Bank in respect of MSME enterprises, and the judgment of the Bombay High Court against which the SLP was preferred, whereby the Bombay High Court had rejected the petition of a similar enterprise on the ground that these MSME, on the ground that the resolution framework published by the Reserve Bank of India is not binding, has been interfered with and set aside. Stop. The Apex Court held that once the proposal is forwarded by the MSME enterprise, the banks are required to examine the same and explore ways to restructure the loan offered to the MSME and whose account has been declared to be NPA. Stop. He therefore submits that the rejection by the bank of the restructure proposal forwarded by the petitioner MSME enterprise is contrary to the resolution and should therefore be interfered with and set aside, and the direction be issued to the banks to reconsider the same and reconsider the same to ensure that the MSME enterprise proposal is accepted and the loan is restructured in terms of the framework, resolution framework published by the Reserve Bank of India. Stop. He further submits that this rejection of the proposal was by an email without any explanation, without any reasons. Although pursuant to the said rejection, another proposal has also been forwarded, which has not yet been considered by the bank. Mr. M. Sharma, Learned Counsel, appearing for the respondent number 1 and 3.
Yes, your lords.
And Mr. Parvez, A. Parvez, appearing for respondent number
2.
Hey, let's go. Submits that the judgment of pro NITS has been subsequently explained by the Apex Court in another judgment rendered in Sri Swami Samarth Construction and Finance Solution in WPC Civil number 684 of 2025, reported in 2025 INSC 908. He submits that the bona fides of the borrower is to be examined, and if the bank finds that the bona fides are not genuine or are doubtful, then the resolution framework published by the Reserve Bank cannot be considered to be binding on the banks, that notwithstanding the bona fides of a MSME enterprise, the benefits under the resolution framework published by the Reserve Bank of India would still be available to the MSME enterprise. Para. Mr. Parvez, Learned Counsel, appearing for respondent number 2,
Yes, ma'am.
also submits that the submits that an account to be declared to be an NPA, the default must be for a minimum period of 90 days. And the account was declared NPA in June 2025. Whereas the restructuring proposal was submitted in January 2026. Therefore, the MSME enterprise was not vigilant enough to avail the benefits of the restructuring resolution, and therefore there was no default in the rejection on the part of the bank in the rejection of the proposal submitted by the petitioner MSME enterprise. Para. Having heard learned counsel for parties and upon careful consideration of the facts urged before the court, and also upon due consideration of the judgments pressed into service at the bar, this court is of the view that the resolution framework published by the Reserve Bank of India is a set of directions which are required to be followed by the bank in respect of the borrowers, more particularly the MSME enterprises, where their accounts have been declared to be NPA. And the process and the procedure for restructuring has been clearly delineated in the said resolution proposals framework. Stop. The judgment of the Apex Court in Prunit had categorically held that these guidelines are not directory but are binding on the banks, and any proposal which is furnished by the bank, by the borrower, is required to be considered in terms of the guidelines to make an attempt to restructure the account which has been declared NPA. So the subsequent judgment rendered by the Apex Court in so-and-so has further explained the judgment of rendered in Prunits, and has stressed the necessity to balance the equities under the MSME Act as also under the SURFACE Act. Stop. The subsequent judgment in Sri Sri Swami Samarth has held that where the bona fides of the borrower are in doubt, and there are reasons to show that the bona fides, the restructuring policy or the attempts made to restructure the loan as submitted by the MSME enterprise are not bona fide. The banks are not restrained from rejecting such proposals. Stop. Para, coming to the facts of the case. During the course of the argument, it has been submitted by at the bar that the loan by the petitioner was for a period of about 22 years. And it was declared as an NPA in June 2025. And the proposal submitted ought to have been submitted within 3 months.
Yes, your lordship, prior to NPA.
Prior to
One thing,
uh,
against section 13(2) demand notice, the petitioner has not given any representation. They could have taken the plea of MSME restructure in that notice.
when was it served?
It was served by respondent number 2 on 25/7/2025. So bank has initiated action under SARFAESI Act. So there is a provision for representation under section 13(3)(a) of the SARFAESI Act.
It was further submitted before the court by the respondent bank that after the account has been declared NPA, the bank has initiated the SARFAESI proceedings under SARFAESI Act and has issued a notification,
Notice, demand notice under section 13(2) of SARFAESI.
under section 13(2) of the SARFAESI Act, to which no reply was submitted by the MSME, by the petitioner. Stop. It was incumbent on the petitioner to immediately bring to the notice of the bank that it is an MSME enterprise and they seek to undertake the benefits prescribed under the resolution framework published by the RBI. However, no such opportunities were undertaken. And after 6 months, the proposal was submitted to the bank.
Well, prior to that also we submitted 2 applications that we are submitting the 15, 12, 25 also we have submitted.
Such submissions, however, are countered by the learned counsel for the petitioner to submit that applications were duly submitted by the borrower to the bank on
15, 12, 25 and 26, 12, 25. That we are MSME, we are filing the restructuring.
12/25, that the proposals are under consideration and will be submitted shortly. Therefore, the bona fides of the borrower petitioner should not be doubted. But having heard the counsel for the parties, and upon due consideration of the facts and circumstances as urged before the court, and also keeping in view the judgments pressed into service, this court has permitted the respondent counsel to complete their instructions as to the stand of the bank in respect of the proposal submitted on
On 1st of January.
1st January 2026, and subsequently.
No, not 16, well, first letters, my lord.
No,
Proposal is, my lord.
when did you submit the proposal?
Second is 23rd January. But the letters were issued that we are MSME, we are filing the restructuring formula, these are 15, 12.
No. You have not submitted the proposal.
Proposal was
Restructuring.
submitted on 1st of January.
You have submitted
Yes.
and followed by
23 what,
23rd,
madam? 23 what?
and
Second.
subsequently
That
on
Second one.
Second,
23/1,
second one.
2026. Where is the 1st January?
Yes, first is my lord,
234.
234.
But where is the, oh, so you have enclosed it?
Yes,
You have enclosed it?
yes. We have documents or
Right. Be it as it may, the respondents will obtain their instructions as to whether the proposal submitted by the petitioner enterprise are workable in, and the benefits available to the petitioner MSME enterprise under the resolution framework published by the Reserve Bank of India are ought to be available to the petitioner, can be examined by the bank, and to that effect, the council shall furnish the instructions on 6th.
Yes, sir.
6th of February. What is the stage now?
Your lordship,
We have taken possession in the month of December. Symbolic possession of the property.
They have taken possession.
yes, yes,
Symbolic possession is taken.
symbolic possession has been taken under.
It is also enclosed here.
as it is submitted by the counsel for the bank before the court, that pursuant to the initiation of proceedings under the SARFAESI Act, symbolic possession of the properties of the bank have been taken, or the petitioner has been taken over. The next date fixed on 6th, we direct the bank authorities not to proceed any further in respect of auction of the said properties for recovery of loan. Further orders would be, as deemed necessary, would be reconsidered on the 6th of January.
My lord, we may allow to serve notice on question of 4, my lord.
Although notices are not issued at this stage, the counsel, the advocate on record for the petitioner will ensure service of extra copies on both the counsel representing the respondent bank within the course of the day. Petitioner is also permitted to take service by way of dusty on respondent 4.
My lord, you can, dusty will take time, my lord, because it is Friday on the fixed. We can
Okay.
serve and.
Or is permitted to serve advance copy.
Office
Is
is
it
here.
in Guwahati? Is it in Guwahati?
Yes.
Is it in Jorhat?
Jorhat. Branch in Jorhat from there where my lord.
All right, he is permitted to serve advance copy of the writ petition. List again on 6/1.
My lord.
6/1.
Yes.
Sorry, 6 February. 6/2/6/2.
My lord, I appear for respondent number 1 and 2, my lord. We are the implementing agency of this project. It is for strengthening of the transmission system, my lord, in the state of Assam, so that electricity is adequately supplied to all the parts of the state, my lord. This is an integrated project for the whole of Northeast.
What is the petitioner's claim?
My lord, petitioners had initially objected to us doing the stringing of the transmission system. They had misconstrued one of the orders to demonstrate that there was a stay. My lord, we had approached the court, and my lord, the coordinate bench had made an observation that there is no stay. Accordingly, the work is going on. They have also made an amendment in their writ petition, my lord, saying that they want adequate compensation. We have filed our counter affidavit, and we have stated that whatever is the compensation,
Are they
as per-
landowners?
landowner, my lord, as per law, we will pay it to them. So they had seek time, my lord, to file a counter affidavit. A rejoinder, my lord, to my counter affidavit. So that is where we stand, my lord, today.
They have not made payments as on date.
My lord, there is a process. We are doing the assessment. We will do the land assessment and then we make the payment as per the Telegraph Act and the guidelines, my lord, adopted by State of Assam in the year 2017.
Are you allowed to take over the land before depositing the amount?
My lord, this is not, yes, my lord, because under the Telegraph Act, we do not acquire the land, my lord. We are only using the right of the user, for which we pay the compensation amount and of the damage that has been done. My lord, assessment of the damage is only possible once the erection and the stringing of the transmission system is done.
When did the construction start?
My lord, it started around 2020-21, my lord. This particular leg, the issue cropped up in the year 2023, and we had completed the other legs. This is the last part of the leg, which we are on the verge of completion.
Why have you not calculated the compensation if it is started in 2021?
No, my lord, this part of the leg, when we have reached there, we have now done the assessment, my lord. They had objected to us to do and they were protesting, so we could not do the on-ground assessment for the damage. It has already been now, with the work progressing, it is being done. So they are to file a rejoinder, my lord.
You are required to file a rejoinder.
As per the last order, they had seek time, my lord.
All right, counsel for the petitioner seeks adjournment to file a rejoinder affidavit as prayed for, as is evident in the earlier order dated 5/12/2025. You're Mr. Khera.
My lord.
Mr. N. Khera, learned counsel, appears for respondent number 1. And submits
1 and 2, my lord.
1 and 2.
My lord, Power Grid Corporation of India Limited.
So the assessments are being undertaken by, on the ground, by the respondents 1 and 2 for adequate compensation for the damages and for the right of use of land belonging to the petitioner's stock. Borman, what do you say?
5 to 7, my lord.
Any submissions?
Lordship, it is basically by the appraisal authorities, my lord. Upon that reassessment, they will get the amount. Otherwise, it is not an acquisition process, my lord. So DC has minimal role to play.
MS and Borman appears for respondent number 5.
5 to 7, my
5 to 7 is APDC.
lordship, then 5, 6.
5 and 6. Yes, Mr.
No, it is.
M. Das for
M does for respondent number 4. I am
respondent.
the contractor who's executing the work.
You are the contractor.
Here, my lord, numbering is wrong, my lord.
Oh.
Circle officer ought to have been 7 and the APGCL is 8, my lord. After 5, 6, there is a double 6,
So who's Starling and Wilson?
my lord.
My lord, we had, they are one of the parties whom we had given the contract to do the work. My lord, we are the actual answering party over here.
No, but who appears for respondent 3?
My lord, they had a representation until the last date. I believe
All right.
they are not here today. They were represented, my lord.
Okay. I think you appear for respondent 3 also.
No, that's right.
That's what the order says. 24, right?
My friend here is for respondent 4, my lord.
4.
3 and 4 as per the order dated
No,
24
no,
night.
I have filed Vakalattam for 4 only, not 4.
Okay, let the matter therefore be listed after, how much time you require?
Sir, fix it on 5th February.
Not 5th. Matter be listed again on 11th February. Enabling the petitioner to file their rejoinder affidavit if so advised in the meantime. List accordingly. Yes.
Highly obliged, my lord.
Please, Lordship. Also, we are praying for an adjournment in this matter. Dr. Seraph's mother has suffered a hip injury.
Prayer is made on behalf of the arguing counsel for personal difficulties which prevents him from appearing in court today. Adjournment is sought for. An accommodation is sought for 2 weeks. 2 weeks. This matter again. After 2 weeks on the 26th
Lordship,
of February.
there's an interim. Lordship.
Interim order passed earlier, we will continue. Anyone for the respondents?
We have informed the respondent and we have sought their consent.
Mr. Sethi appears.
Lordship. Public.
I think 4 and 5.
My lord, this is for the appointment of arbitrator. And in this respect, your lordship may kindly see, this is the old case, my lord. On 4/9/2015, the petitioner invoked the arbitration clause at page 157. Annexure 19.
Yes.
Now, my lord, on 5/1/2016, at page 164, the respondent appointed 3 railway officers to act as arbitrator.
Where do you, is there any list of dates?
List update is there, my lord, in the petition itself, it is there. From page number 1 to 3.
Okay, 24/7/2009.
Yes.
Then,
Then, my lord, on 5/1/2016, they appointed the arbitrator, railway officers, at page 164.
hmm, yes, then,
Now, my lord, I invoked the arbitration clause on 4/9/2015. But before appointment of the arbitrator, the amendment came into force.
arbitration এখন নেই। $12,500.
Yes, my lord. The Arbitration and Conciliation Amendment Act 2015 came into force with effect from
2310.
23/10/2015. And this section 26 of the amended act, my lord,
Hmm?
says that nothing contained in this act shall apply to the arbitral proceeding commenced in accordance with the provisions of section 21 of the Principal Act. Before the commencement of this act, unless the parties otherwise agree.
Sorry.
This is important, my lord. But this act shall apply in relation to arbitration proceeding commenced on or after the date of commencement of
You are reading which clause?
this section 26 of the amended act, my lord. Separately, it is there. In the old act, this,
Section 20.
26 of the amended act of 2015.
So bringing, which amendment?
This is the entire amendment relating to the section 11, section 12.
Uh,
It came into force with effect from 23/10/2015. And the amended act says the application of this, it will be separately in the Bear Act.
It's not here. No, what do you want to point out from there?
Now, I would point out, my lord, now your lordship may kindly come to section 20A,
20.
29A, 29A.
Uh, Yes. Time limit.
Time limit, my lord. So here, my lord, the appointment was made on 5/1/2016. And after the amendment act, my lord, then the period, my lord, 29A, the award shall be made within a period of 12 months from the date the arbitral tribunal enters upon the reference. For the purpose of this section, an arbitral tribunal shall be deemed to have entered upon the reference on the date on which the arbitrator, for all the arbitrators, as the case may be, have received notice in writing of their appointment. If the award is made within a period of 6 months from the date of the arbitral tribunal enters upon the reference, the arbitral tribunal shall be entitled to receive such amount of additional fees as the parties may agree. Subclause 3, my lord. The parties may, by consent, extend the period specified in subsection 1 for making award for a further period not exceeding 6 months. In this case, no extension was made by the parties, my lord. 4, my lord, if the award is not made within the period of specified in subsection 1 for the extended period specified under subsection 3, the mandate of arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. So here, my lord, after expiry on 5/1/2017, the mandate of arbitrators terminated by operation of law. So no arbitration was there, no arbitrators were there, my lord. Thereafter, what happened, my lord?
No, what happened to the arbitration proceedings? When the arbitrators were appointed,
Yes,
they did not proceed for
no,
arbitration.
no, my lord. So after expiry of 1 year, they wanted to change.
Hmm.
Next page, lordship may kindly, see. This is important. Page 166, my lord.
Yes.
This on page 167, 2018. They issued another letter for changing the arbitrators. Then thereafter, at page 167, again they issued a letter. This is the important, my lord. 19/9/2018. They issued the letter for nomination of name of the new arbitrators of the railway officers with the format for waiving the right provided under section 12(5).
Hmm.
So they accepted that the amended act will be applicable.
Hmm. Then.
Then, my lord, I declined to waive
Hmm.
as after coming into force of the amended provision of section 12(5), the railway officers have become ineligible to be appointed as arbitrator. So this was my right. I exercised my right, my lord.
Hmm.
So, my lord, then I approached this honorable court, my lord, for appointment of the independent arbitrator, my lord.
Hmm.
And when the mandate automatically terminated, there is no arbitrator in the eye of law, my lord. And the Honorable Supreme, I am referring one case, my lord, Honorable Supreme Court says, if the appointment was made, and similar case is made, this facts of this case is similar, my lord. Here the appointment was made before the coming into force of the new act. But arbitrator did not start the arbitration proceeding. In the meantime, the amended provisions came into force. So Honorable Supreme Court allowed, my lord, and appointed the arbitrator as the amended provision will be applicable in the arbitration proceeding.
Which paragraphs?
Paragraph, my lord, 2.5. Rather, my lord, I would like to refer this paragraph 2.2, my lord. From there, I am reading, my lord. Then the position will be clarified. The appellant thereafter file another suit seeking recovery of an amount of rupees so and so being so and so at Civil Court Bhopal. In the said suit, the respondent preferred an application under Section 8 of the Arbitration Act 1986, seeking stay of the proceeding on the ground that
22.
there exists an arbitration clause in the agreement between the parties. The civil court rejected the said application, wide order that is so and so. The respondent filed revision petition number so and so before the High Court, which came to be allowed by the High Court, wide order dated 3/5/2000. The High Court referred the parties to arbitration by a stationary purchase committee comprising of the officers of the respondent. Now paragraph 2.5, my lord. Subsequently, the appellant filed the present application before the High Court, being so and so under section 14 read with section 11 and 15 of the Act, seeking termination of the mandate of originally constituted arbitration. A stationary purchase committee comprising of officers of the respondent. and for appointment of new arbitrator. Before the High Court, the appellant herein heavily relied upon the section 12(5) of the Arbitration Act 1996, relying upon the decision of this court in the case of TRF. It was submitted on behalf of the appellant that all 5 officers constituting the stationery purchase committee, being the employees of the respondent, had rendered themselves ineligible to continue as arbitrators. It was submitted that since they had become ineligible to continue as arbitrators, they also could not appoint another arbitrator as arbitrator. It was also contended that the originally members of the arbitral tribunal who initiated the proceeding had since ceased to hold their respective offices. In any case, a new arbitral tribunal has to be constituted, and therefore an impartial and independent arbitrator was required to be appointed in terms of Section 11 of the Arbitration Act 1996. On behalf of the appellant, paragraph 2.6. However, after referring to and considering the decision of this court in the cases of so and so, the High Court has not agreed with the submission on behalf of the appellant. Referring to the aforesaid decision of this court, it is observed and held by the High Court that the Amendment Act 2015 shall be made effective with effect from 23/10/2015 and cannot have retrospective operation in the arbitration proceeding already commenced unless the parties otherwise agree. And therefore, when in the present case the arbitral tribunal was constituted much prior to the Amendment Act 2015, and the arbitral tribunal commenced its proceeding, the Amendment Act 2015, Section 12(5) of the Arbitration Act 2016 shall not be applicable. Observing so, the High Court by impugned judgment and order has dismissed the application filed by the appellant hearing under Section 14, read with Section 11 and 15 of the Arbitration Act 1996, and has observed that it would be open for the appellant to participate in the proceeding before the arbitral tribunal constituted by the respondent as a stationery purchase committee. Mr. So and so learned advocate appearing on behalf of the appellant has vehemently submitted that impugned judgment and order passed by the High Court rejecting the application submitted by the appellant under Section 14, read with Section 11 and 15 of the Arbitration Act 1996 is just contrary to the recent decision of this court in the case of Jaipur Zilla Dugh Utpas Sahakari Samiti Limited versus Ajay Cells and Supplies. It is submitted that as held by this court in the aforesaid decision in view of the mandate under subsection 5 of Section 12, read with 7th schedule, the arbitral tribunal constituted in the present case, a stationery purchase committee consisting of the officers of the respondent, has lost its mandate. It is submitted that continuation of such arbitral tribunal would be frustrating the object and purpose of the Amendment Act 2015.
Here, how many arbitrators were to be appointed?
One sole arbitrator
In the facts of your case?
in this case, my lord.
In your case, as per the agreement?
Yes.
Three.
Three as per the agreement,
Three.
three.
So what is the stand of the railways?
In the first matter, my lord, my colleague is appearing, my lord, in this next, my lord, 5, my lord. Item number 5, my lord, I am appearing, my lord.
I don't know what.
And both are, my lord, more or less similar, my lord. My lord, in my case, my lord, the arbitrator appointed, my lord, and my lord, the statement of claim filed, statement of defense is also filed, my lord. Thereafter, my lord, there is a problem, my lord. The arbitration could not be completed, my lord, in my case, my lord. So, my lord, now, my lord, in my case, my lord, the pertinent question will be the, my lord, termination of the mandate of the arbitrator, my lord. So, my lord, termination of the mandate of the arbitrator can be done, my lord, only, my lord, as per, my lord, the provision of this act, my lord, under section 13, 14, 15, 25A, 30 and 32, my lord.
No, what happened to the arbitration?
My lord, they are going on, my lord. Now, my lord, what happened, my lord?
Going on?
Yes, my lord. Arbitrators were appointed, my lord. 3 arbitrators appointed, my lord.
Sir.
One, my lord, had, my lord, was transferred out,
and my lord, we wanted to replace him with another arbitrator, my lord.
Hmm.
Then, my lord, this 11-6 petition was filed, my lord, that since new act has come, my lord, you cannot appoint arbitrator, my lord. But my lord, since my lord, in my case, my lord, the arbitrator were already appointed. So my lord, the replacement has to, my lord, and there is a provision of replacement, my lord. So it has to be done as per the provision of the contract agreement, my lord. And the contract agreement provides for, my lord, replacement of the arbitrator, my lord.
No, but your curated arbitrators cannot be appointed unless they give a waiver.
But my lord, our appointment was done, my lord, earlier. Before.
Maybe, but now the arbitration could not be completed within the period of 1 year.
My lord,
Assuming that your
my lord, that
arbitration.
provision was not there, my lord, at that point of time, my lord.
No, whatever provision is there,
My
but
lord, so my lord, that, my lord, my respectful permission, my lord, that will not come, my lord, here.
so what happens now?
So my lord, we are entitled to, my lord, appoint the arbitrator, my lord, and my lord, if there is, my lord, the mandate of the arbitrator, my lord, ends, my lord, that has to be, my lord, 11-6, my lord, by 11-6, my lord, this mandate of the arbitrator, this consideration cannot be made under 11-6, my lord. Whether the
No,
mandate of the,
mandate we are not considering. We are is here that the arbitration has failed.
my lord.
Therefore,
No, my lord, that fails, my lord, that means, my lord, the mandate of the arbitrator ends, my lord.
no, mandate of the who has appointed the arbitrator?
My lord, my lord, railway, my lord.
Did you file an application for substitution?
My lord, there is a provision in the contract agreement, my lord. If, my lord, any one of the arbitrator, my lord, transferred out, my lord, from here, my lord, we can replace him, my lord. That is the provision, my lord. We gave him a name, my lord. He has not accepted, my lord. He has come by way of 11-6, my lord. So my respectful submission is that, my lord, the mandate is there, my lord. If, my lord, he at all, my lord, he says that there is a.
Have you read the
My lord,
the
lordship,
specific provisions in 12.5?
yes, my lord. Yes, my lord. Yes, my lord.
Begins with a non-obstantive clause.
My lord.
Just one thing I would like to point out, your lordship, may kindly.
My lord, I would like to, my lord, point out, my lord, section 14, my lord, of the Arbitration Council Act, my lord. My lord, it is said that the mandate of an arbitrator shall be terminated and he shall be substituted by another arbitrator if he become de jure, de facto unable to perform his function or for other reason fails to act without undue delay. My lord, here is the cause, my lord, undue delay. Undue delay. My lord, as per there, my lord, we could not complete it, my lord, for a long period, my lord. And my lord, second, my lord, is, my lord, the coming of the new act, my lord. But since my humble submission is that, my lord, since, my lord, it was arbitrator were appointed, my lord, before the, my lord, coming of this act, my lord, so, my lord, that embargo will not affect in my.
You read 12.5 and tell us.
My lord, yes. 12.5. My lord, yes, my lord. But my lord, 12, my lord, it will come, my lord. 12.5, my lord. I'll read, my lord. 12.5. 5. Not to say any prior agreement to the contrary, any person whose relation with the prior parties or counsel or subject matter of the dispute falls under any of the categories specified in the schedule 7 schedule shall be ineligible to appoint as an arbitrator. My lord, again, my submission is, my lord, this provision has come, my lord, subsequently. My lord.
Therefore, I have asked you to read and reread 12.5.
Provided the parties may subsequent to dispute have arisen between them, waive the applicability of subsection, subsection by an express agreement. My lord,
That waiver he has refused. He is not given.
no, my lord. My lord, I'll show one judgment of this honorable Supreme Court, my lord. My lord, you may kindly see this, my lord. My lord, similar conduct.
This is what is the difficulty. You see, you don't give a list of judgments you want to rely on.
My lord, only one judgment, man. Only one judgment.
You give judgments.
My lord, I'm sorry, my lord.
Troubling
I should have
read these judgments here.
No, my lord. I'm sorry, man. My lord.
Court is not a repository of endless number of judgments. We also have to read it.
My lord.
Then? Yes, paragraph.
Lordship may kindly come to para 9, my lord. Para 9, my lord. 9.1, my lord. 2022 10 SCC 230 9.1, my lord. My lord, these are the issues frame, my lord. The following question arise out of consideration: whether the High Court, in exercise of power under section 11(6) of the 19th Act, can terminate the mandate of solar
He
arbitration.
cannot, because
Well-
there is a specific provision.
My lord,
But
Yes,
when the application is before for appointment of an arbitrator,
my lord.
and the authority who has appointed an arbitrator does nothing to proceed in the arbitration, and insists on appointment of an arbitrator in contrary to provisions of section 12(5), what is to be done?
Now, my lord, I'll come to the last para, my lord. Kindly see, my lord. Last para, my lord, concluding para. My lord. Para 34, my lord.
Para
34.
34.
In view of the aforesaid discussion and for the reasons stated above, the impugned judgment and order passed by the Honorable High Court is unsustainable and the same deserves to be quashed and set aside. And accordingly quashed and set aside. The controversy and the dispute whether the mandate of sole arbitrator under section 14(1)(a) of 1996 Act stand terminated or not shall have to be considered by the court of an application filed under section 14(2) of the 1996 Act. It is reported that after impugned order passed by the High Court, respondent 1 to 3 have withdrawn their application under section 14, subsection 2 of 1996 Act. To do substantial justice between the parties and to ensure that the respondent 1 and 3 are not left remedialess, we direct that applicants submitted by the respondent 1 and 3 before the court concerned under section 14(2) of the 1996 Act shall stand revived. Now the court concerned before whom the application under section 14(2) of the 1996 were filed shall consider the same in accordance with the law on their own merit at the earliest and preferably within a period of 4 months from the date of receipt of the present order. It goes beyond to saying that if ultimately it is held that the mandate of the sole arbitrator is terminated as per 14(1) of the 1996 Act, and more particularly on the ground that there was undue delay on the part of the arbitrator in concluding the arbitration proceeding, the arbitrator has to be substituted and fresh.
Here the bar of 12(5) was not there.
Well,
Here the bar under 12(5) was not there. You insist on appointing an arbitrator notwithstanding 12(5) incorporated. 12(5) says notwithstanding any prior agreement to the contrary.
But if I read the situation is here same manner. We wanted to substitute the arbitrator, they are saying that we cannot substitute.
Naturally, they are under, they have been given the right under the provision of 12(5). 12(5), it's not mandatory that they will have to agree to your suggestion.
Once arbitrator has been appointed, arbitrator proceeding has been started, year after this will not come. It is my respect.
That you show us on some authority that these provisions of 12(5) will not be applicable once the proceedings have initiated. Yes, what do you say, Mr. Hussain?
Just your lordship, may kindly come to page 72, my lord. The arbitration clause is there.
No, you show us any authority that once the proceedings were initiated prior to the amendments,
Yes.
subsequent substitution or replacement of an arbitrator
Yes. Just your lordship, may kindly.
will have to be done in terms of the provisions of the act.
I
the
satisfy your lordship.
provisions of the
Yes.
contract.
I have got the point. I will satisfy your lordship. Just your lordship, may kindly come to page 72. Just I would like to point out one.
72.
Yes.
Yes.
Here, the arbitration clause is there, clause number 64.7 in the bottom, your lordship, may kindly see. Subject to the provisions of the aforesaid arbitration and conciliation in 1996 and the rules thereunder and any statutory modification thereof shall apply to the arbitration proceeding under this clause. It is their agreement. So naturally, they.
No. what is how to interpret the provisions of 12.5
Yes,
in respect of an arbitration which had already commenced,
yes,
but for the default of one of the arbitrators by way of transfer or retirement or whatever, he could not proceed. Now, their attempt to replace or substitute an arbitrator has not been agreed to by you by pressing 12.5.
yes. I will satisfy your lordship. I will bring some.
Satisfy
case
us.
on that.
Do you have the judgments with you now? No.
No central organization case in Supreme Court says if the arbitrator is ineligible, then automatically it will be terminated. I will bring that.
No, no. Where it had not commenced,
Yes,
where the proposal is to refer the matter to arbitration by appointment of curated arbitrators. And in the meantime, the amendment had come in. Then these are cases where unless you agree to the waiver,
here
may
this
not
case.
be applicable. Here is a case where you agreed.
Yes,
It was proceeding.
proceeding. So now the proceeding is there, but the mandate of arbitrator by operation of law terminated.
And number two, this is an application under section 11. You will have to first file an application for cancellation of the mandate of the arbitrator.
No, my lord, when there is a arbitrator, then I can file the petition for termination of the mandate.
There is an arbitrator.
In the eye of law, as per the provision section 29A, there is no arbitrator after expiry of the period. They are ceased to be arbitrator. In recent judgment, Honorable Supreme Court says they are ceased to be arbitrator. They are not treated to be, they cannot pass any order also after expiry, unless the mandate is extended by the court. Recent judgment.
Where is that?
I will bring that judgment. Citation I have. And the Honorable Supreme Court says after expiry, the mandate of arbitrator cannot be extended also. Before expiry, application has to be filed. And here, in this case, which I have referred, my lord, Elora Paper Mills, here the arbitrator was appointed before coming into force of the new, amended provision. And he continued. Though he has not started the proceeding.
You're referring to section 14 and 15.
No, section 11, my lord. My application is under section 11.
No, your application is under 11, but
Yes.
you are saying that once the period expires.
29A, section 29A. Section 29A, subsection 4, my lord. If the award is not made within the period specified in subsection 1 or the extended period specified in under subsection 3, the mandate of arbitrator shall terminate by operation of law. And admittedly, nobody has approached the court for extension, either prior or after expiry of the mandate.
All right, we'll take it up day after tomorrow.
Yes.
My lord, one thing I would like to point out, my lord, regarding my lord, section 29, my lord. My lord, 1 year, my lord, that provision of 1 year, my lord, that has come to my lord, from my lord, effective from 23/10/2015, my lord. So my lord, anything, my lord, before that, my lord, arbiter, I will consider that,
No,
my lord.
but what was the position prior to that?
My lord, it was going on.
No. Are you saying that there is no provision for conclusion, time limit for arbitration?
My lord, 10th, my lord, it will come, my lord, under, my lord, section 14, my lord. Undue delay, my lord.
Time limit starts from the starting the proceeding by the arbitrator. And arbitrators
My
were
lord-
appointed after amendment provision.
29A came, my lord, after 2015, my lord. And my lord, before that, my lord, the provision of section 14, my lord, delay. Sorry. Under section 14, my lord,
Notice was issued under
এইটো বন্ধ
my lord,
কৰক।
section 21.
আকৌ এবাৰ কৰিম। Okay, day after tomorrow for further hearing. So parties. The parties are permitted to submit the case laws which they propose to rely in these matters before the next date. Day after.
And in this matter, I'm appearing as a legal aid counsel. Initially, a different counsel is there, subsequently I came in. But it all refers to the prayer for compensation of the writ petitioner on account of delay caused in disbursement, release of scholarship, which subsequently entailed some pecuniary losses as well. And on the other part, so far as his caste status is concerned, there was some complaint which moved on and initially and subsequently at page 148. At 148, the National Commission for Scheduled Caste, which is a constitutional body, of course, had passed the order. This, the penultimate part, or I may read the order if it's a brief order, my lord. The matter was fixed for hearing on 9/9/2022 at 11 a.m. before the Vice Chairman, National Commission for Scheduled Caste, NSCSC, in his chamber, 5th floor, Lok Nayak Bhavan, Khan Market, New Delhi. The petitioner informed the commission that he is the first scheduled caste candidate in the entire Northeast India, beneficiary of centrally sponsored scheme for post-matric scholarship for scheduled caste students for undergoing commercial pilot license course.
No, what exactly happened here?
Here, the page 149 towards the last part, paragraph if I may read.
So we've seen the order.
Yes.
He
So
belongs
direction,
to a scheduled caste.
so recommendation for compensation was issued.
No. Why was the compensation necessary to be recommended? Why was the compensation
There are two
important?
parts. So far as the scholarship part is concerned, there was a delay in release of scholarship.
He applied for or he was?
No, he applied for,
Uh,
it was verified, it was released, but there was a considerable delay for which he entailed, difficulties, even to sell the land and all, etc. These part compute to the first part of the payment, prayer for compensation. So far as the other part is concerned, the other part is on the allegation of his caste status. This precisely started with a complaint at page 78. The order refers to all these pages, page 78. Page 78 is the page where one Amarendra Das, member Scheduled Caste Development Council, had lodged a complaint to the Director Welfare of Scheduled Caste on this caste status. Now, this was negated by the Deputy Commissioner, Jurisdictional Deputy Commissioner's report at page 85 and the DSP CID's report at page 114. And eventually, a speaking order was passed at 115. Now, so far as this writ petition is concerned, a day or two back, I'm under instruction from my client. He has made this prayer. If I may just pass it on, So summarily, he's requesting to me to place before the Honorable Court, basically, directions be given to the authorities to compute and process within a time frame. Basically.
So I need not go to the details present. May I read that, madam? I would request to kindly pray before the Honorable Guwahati High Court on the next date of hearing, 3rd February 2026, for issuance of appropriate directions inter alia on the following grounds. 1. Calculation and payment of compensation by Deputy Commissioner Kamrup Metro, Party Respondent number 4. That the Honorable Court may be pleased to direct the Deputy Commissioner Kamrup Metro to calculate and disburse the amount of compensation payable to me in connection with dispute PS case number 404821, strictly in terms of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Rule 16, and further to pay interest on the compensation amount on account of delay beyond the prescribed period of 7 days from the date of registration of the FIR under SC/ST Act 89, that is from February 22 till date. Number 2, calculation and payment of compensation by Department of Social Justice and Empowerment, Government of
He's
Assam.
entitled to 2 compensations.
Yes, one under the SC/ST Act, because the moment we lodge it, means under the rules are there, is scheme out there. This scheme would be taken out by the Deputy Commissioner. That's one part. So in substance, not so many words, is praying that there be direction for time-bound computation and release.
Second compensation?
Second compensation is a direction to the Deputy Department of Social Justice and Empowerment, is to direct Department Government to calculate and release appropriate compensation for huge loss suffered to be in order in release of my scholarship amount. That prayer is, it is the order which I pointed at 148. At 148, it recommends that the Commission recommends that the petitioner be given compensation accordingly. Now, obviously, this computation would not be done by the Honorable Court or any other court. So basically, it has to fall back, as an officer of the court, I also understand that this has to go there. A computation be done, so the department, the Commission would not do it. So Department of Social Justice and Empowerment, Government of Assam, 189.
No, this compensation by the SC/ST Commission
My lord.
will be quantified by the Deputy Commissioner.
SC/ST, one is the registration of the FIR. This gives rise to the rules of 16, under which on the Act, there is a time-bound schedule, what to get, what not to get. This computation has to be done by the jurisdictional Deputy
Let us
Commissioner.
see the rules.
So far as the other one is concerned, this part-
SC/ST.
At page 155, Lordship may have the notification also. 155.
Where is the rules regarding the compensation?
My lordships.
Page 159.
My lord. Page 32, paragraph 23, it has been pleaded below. I've seen that the pleadings are there so far as the entitlement and under which heads. So this would be the jurisdictional Deputy Commissioner below. And so far as the Commission has recommended for compensation, that part respond numbers 8 and 9.
No, it's not clear. You're saying that under the finding of the Commission is that it recommends, number 1, to reinvestigate and arrest the person who made the
Yes,
false
yes.
complaint.
And the last part,
嗯
148, the last part, 149.
Hmm.
Due to this, the petitioner incurred huge loss. The Commission recommends that the petitioner be given compensation accordingly.
So this compensation is.
This
to-
compensation will be computed by respond numbers 8 and 9. I mean,
No, this compensation needs to be worked out in terms of the regulations, rules.
no, not in these rules. This is the loss I suffered for the delay in release of the scholarships. This has nothing to do with my caste status, as I can understand.
No, but what is this recommendation for?
Compensation.
Uh,
If I read this paragraph, it would be clear. May I just read the 48 and 49, 2 paragraphs?
Yes.
The matter was listed of hearing on 9/9/22 at 11 AM before so-and-so in his chambers at so-and-so such and such place. The petitioner informed the commission that he is the first scheduled caste candidate in the entire Northeast beneficiary of the centrally sponsored scheme of post-matric scholarship for the scheduled caste students for undergoing commercial pilot license. One middleman lodged a fake complaint against the authenticity of the scheduled caste status and intentionally delayed the payment of my scholarship, thus preventing timely completion of my ongoing pilot training course. Thus he filed an FIR against the official who is involved in this, but no charge sheet has been filed by the IO within the stipulated time period of 60 days from the date of registration of the FIR as per so-and-so. The authority informed the commission that the IO submitted a prayer before the Honorable Court for adding under section 3(2) so-and-so of the SC/ST Prevention of Atrocities Act 89. Accordingly, the Honorable Court passed an order to add section. The said case is re-endorsed by the Deputy Commissioner of Police, East Police District, Guwahati, White Memo so-and-so dated 8/2/22, but case diary of the case is yet to be received. After hearing both the party in detail, it is found that the commission that the additional secretaries who appeared in the hearing have delayed the matter intentionally, which could have been settled at their end. The purpose of the post-matric scholarship for scheduled caste students was totally defeated due to the negligence of the concerned officers, which led to undue hardship of the petitioner, and he had to sell his land and mortgage his properties to pursue his studies. The commission recommends the concerned police department to reinvestigate and arrest the person who made this false complaint against the petitioner, which eventually led to the delay of the process of scholarship to the petitioner. An appropriate action may be taken against WTC and VC department who ordered to reinvestigate the caste certificate of the petitioner. Due to this, petitioner incurred huge loss. The commission recommends that the petitioner may be given compensation accordingly.
Then,
But I must be fair. One thing, I must be honest. Once I have gone through the petition, he has claimed a compensation of 532 crores. Whatever his loss he suffered, the consequential and triggering losses he suffered in his career, that is what he computed. It was earlier drafted, I was not there. Rightly or wrongly, the writ petition is continuing, and I'm addressing this court, honorable court, as a legal aid counsel. Now, this prayer which he has requested me, in communication, is just not to the amount, but it says, identifies the authorities who may take a call in a time-bound manner. That's all.
we understand that, but what we are not understanding is the conclusion arrived at by the
I
commission.
understand.
Commission recommends, there are two recommendations.
Yes.
Number one, the police department to reinvestigate
My lord.
and take steps accordingly against WTC and BC department.
As also this person at page 78.
The person who lodged the FIR.
My lord.
And he suffered huge loss. The recommends be given a compensation. That's a recommend.
That recommendatory part does not enlighten upon the computation part.
No, but who is to compete? this?
Therefore, he is praying, my lord,
Yeah.
respond numbers 8 and 9 by the Department of Social Justice and Empowerment.
Where under the provisions of the act, what
So far as the
consequences
act is
follow in
concerned,
terms
it
of
does not come in here.
recommendation?
Act does not come in here. Act would be separate. On the lodging of the FIR, it triggers off here. So Act would take a different compensation.
Huh?
So far as the recommendation of the commission is concerned, it does not come within the purview of the Act.
Why?
This is only on the lodging of the FIR, which comes in lordship, kindly have page 32, paragraph 23. I understand it's not so clearly drafted, you know, but this is it. Paragraph, page 32, paragraph 23.
There are 23.
My lord. May I read?
Yes.
That the petitioner begs to state that any victim of atrocity who registered a case under the SC/ST Prevention of Atrocity Act 89 is entitled to get compensation as per Annexure 1 Norms of Relief published in the notification dated 14 April 16 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Amendment Rule 16. In connection to the offences sections mentioned in FIR 404821, the petitioner should get compensation as per serial number 2, 16, 17, 40, and 41 of Annexure.
This application before the commission, the proceedings have come to an end.
Before that commission, it's yes, that would be an. This is on the logic of the FIR.
No, because if you read paragraph number 4, there is some action taken report to be submitted within 21 days. Page 149.
Yes. Action taken report, I understand what lordship feels. So far as the compensation also would cover there.
Hmm.
Now, so far as the commission is concerned, proceedings would not continue there. Only
don't
the
know.
report part is there.
We don't know, it doesn't dispose of the application.
Now, respond number 7 is a National Commission for Scheduled Caste Government of Assam in India.
When there is an action taken report to be submitted within 21 days,
I understand.
it obviously
It's
reads
then to
that-
respond, respond number 7 would be there.
May I point out one thing, my lord? My lord, lordship, if your lordship takes up the affidavit filed by the respondent number 3, it starts from page 188.
Hmm.
There seems, my lord, whatever he is claiming that only for the delay, he is entitled to all the compensation. He suffered a huge loss and it's not correct, my lord. It has been controverted by the deponent.
No, we'll come to that. What we want to understand first is, this appears to be a tentative finding of the commission. Commission has directed reinvestigation. Directed the police department to reinvestigate and arrest the person who made false complaint, which eventually led to the delay of the process of scholarship, and appropriate action also be taken against the officials. Now, which presupposes that there is some proceeding pending before the police in form of an investigation, some affair, some complaint, which now will have to be, the investigations upon being concluded, the matter goes to the court, either in the form of a charge sheet or in the form of a final report. So what is the status there? Let us assume, hypothetically, that it results in a final report. What happens then?
Then it runs counter to the observations at page 140,
Exactly.
because that's not challenged by anyone.
Huh.
Page 149.
Therefore,
No.
the action taken report by the commission would be relevant.
Very relevant, my lord. Therefore, the respondent number 7,
Huh.
respondent number 7, who's a party here, my lord, would have to explain on that.
Who is respondent 7 here?
The National Commission is there.
Since,
You are appearing.
Lordship, in fact, my colleague was appearing and this is some.
So it is not advisory, my lord. We are only on the present status of it.
I try to get the updated status, but whether the investigation, because that is a part which has to be done by the state authorities, perhaps they could
Naturally.
also be it could be done by them. But the updated status so far as the commission is concerned,
Huh.
what is the status out
What
there?
is the status and
I
what action taken report have been filed?
That I will find out, Lordship.
And whether the representation is still pending there or not,
Lordship, that I will find out.
right? And who can take information regarding the status of the
Police case.
investigation, police
The
investigation?
government council, my lord, concerned.
State. Mr. Das? Where does one get the information of the police pending?
148, my lord.
Reinvestigation of status to.
Shows it, right?
In fact, the commission perhaps intended to have a look at the CD.
In other words,
In other words.
Because
Because it is, no, not in other words, it's fairly clear from
action
the
taken
first,
report.
first lines of page 149.
Scan, it cannot be received.
CD of the
Yes,
case
sir.
is yet to be
Yet to
received.
be.
That, my lord, I would give.
So perhaps they wanted to know what is the stage of the investigation.
Lordship, that is apparent from the.
But what is more surprising is that this has some observations which otherwise are not under challenge and none have appeared till date as in through implement.
Which observation?
This observation will.
I guess this authorities, Lordship.
Yeah, I'll just be here.
No, so the authorities and the persons, the investigation is directed by the Deputy Commissioner of Police.
Correct.
Page 192, if a lordship comes, para 18. An affidavit by respondent number 9.
Street.
192.
192, my lord. Para 18, little bit below, my lord. In this connection, the deponent state that a complaint was lodged by the petitioner before the Deputy Commissioner of Police, on the basis of which has been registered by the Dispur PS GR case number 17856 of 2021. And the investigation was carried out. Prior to the above mentioned GR case, another Dispur PA case 2417 was also filed by the petitioner. These were the two cases filed by the petitioners. my
So
lord.
what is the status you get us? You give us
Status I can bring my.
status you get,
Yes, yes.
and assuming there is some conclusion in resulting in a charge sheet, then besides the criminal proceedings, is the petitioner entitled to any compensation in terms of the
Uh,
recommendation?
Page one.
And if so, who is to quantify
Page
and pay?
160. 160, my lord, if you come to, if your lordship come,
116,
160, my lord.
160. Yes.
Below, my lord, 16, instituting false, malicious or vexatious legal proceeding.
So this is,
Para six, if
this
it
is,
comes,
this is in the event of conviction of that person.
yes, my lord. Itself is there, my lord. And it only recommends, my lord.
So that's all right. Recommendations pursuant to a statutory,
Constitutional.
pursuant to a statute, and has to be taken to be a direction.
I'll get the status of these two cases.
Otherwise, there will have to be some meaningful, some meaning will have to be given to these recommendations and the compensations which are shown
Otherwise,
here.
there are 17, it says 1 lakh rupees to the victim for reimbursement of the legal expenses and damages,
Yeah.
whichever is less.
Yes.
1 lakh, 25% at the instance of the FIR, 50% when search sheet has been filed, and 25% when convicted by the lawyer court. My lord. 17.
First, Lordship, we have to understand whether a charge sheet has been issued
Exactly.
or whether it has ended in a FR.
FR, my lord. That's true, my lord.
But that will be one limb of the pyramid.
Hmm.
So far as the fallout under the SC/ST Act and all. The other part, this recommendation part would go two ways now.
So that's what we are not understanding, because this incurred huge loss.
Yes.
The
This
commission.
triggers out to the loss otherwise to be computed by the concerned department.
One more submissions.
Whether the recommendation of the commission for compensation is to be understood only under the ST/SC Act or any other, or maybe a general compensation.
General compensation also.
That is not clear from the
And the second is there-
recommendation.
Because under the act, it flows under the statute.
How can the commission recommend compensation under
I understand. But that-
generally?
but that was not-
Without there being any attempt to.
True, very true.
compute.
But that aspect of the matter was neither challenged nor called for review nor addressed by any
Alright,
person.
Heard Mr. S. Panik, learned counsel, learned legal aid counsel appearing for the petitioner, as also Mr. R.K. Dev Chaudhary, learned DSGI appearing for
6 and 7, Lordship.
respondents 6 and 7, Mr. N. Das appearing for respondents number 1,
1,
4 and 5.
1, 4 and 5, my lord.
MS learned counsel representing the social justice,
Social.
2 and 3.
appearing on behalf of
2 and 3, my lord.
2 and 3 also.
No, my lord, my friend, my lord.
Only for 3 or 2? Only 3.
No,
I think 2 Mr. Ardhor used to appear, subject to correction. Right. Now, Para, the petitioner before the court is seeking compensation in terms of the order dated 9/9/2022, passed by the National Commission for Scheduled Castes in file number so-and-so, to Silo, page 148, on a representation filed by the petitioner alleging harassment by persons named, as a consequence of which the award of scholarship for which the petitioner was shortlisted came to be delayed, resulting in incurring expenditure for pursuing his course for obtaining a commercial pilot's license from under the Government of India scheme, is it? Government of India scheme. Stopped. The commission, by the said order, directed as follows, in order to extract political, 148, 149. Better. The reading of the order, the commission reveals that the commission recommends reinvestigation of the matter, which has been, which is already before the police authorities, investigating authorities, and also further recommends compensation to be awarded to the petitioner accordingly. Stop. The learned counsel for the petitioner has placed, learned legal aid counsel appearing for the petitioner has placed before the court a representation received from the petitioner that presently the petitioner prays for calculation and payment of compensation by the deputy commissioner in terms of the scheduled caste and scheduled tribes within bracket prevention of atrocities amendment rules 2016 with further interest on the compensation amount on account of delay, and further for calculation and payment of compensation by the Department of Social Justice and Empowerment for the huge losses stated to have been suffered by the petitioner due to the inordinate delay in release of his scholarship amount. Better. In order to consider the claims made by the petitioner, at this stage, it is necessary to understand whether the proceedings before the National Commission of Scheduled Castes have finally concluded or the matter is still pending. Stop. The status thereof will be placed before the court by the learned DSGI. Stop. Better. In respect of the police cases pending, more particularly, Dispur Police Station case being GR case number 17856 of 21 and GR case
And Dispur PS.
Dispur PS case number 2417 of 2019 filed by the petitioner and the status of the investigation thereof. He also placed before the court by the learned governor advocate, Mr. N. Das. The status will indicate whether the case, whether the charge sheet or a final report, as the case may be, has been filed by the investigating authorities. Para. The counsel representing the social justice will apprise the court as to the methods and the procedure for working out the compensation as recommended by the commission for so and so, and also apprise the court thereon. Let all these information be placed before the court on
Because sometime I believe. First week of March. Only say one. Second week.
March on 9.
Let it be on 9th. 9 month. Sorry.
11 March,
That's fine, Lordship.
11 March.
Grateful.
My lord, I have asked for the notification from the department. I have not received yet. I'll place tomorrow. Can it be tomorrow?
Huh?
I'll place tomorrow, my lord. I have not received yet.
Tomorrow,
My lord,
or let us have it on 6th.
my lord, my lord. My lord,
6th.
6 months.
All right.
Now, my lord,
Come
the
let's-
provision of the acts itself, my lord, clear.
Uh,
If it is not by the, my lord, registered, it has to be considered by the secretary.
So let that
Now, other day,
notification
my lord,
come,
my friend for the BTC.
whether it is, whether the notification says that or something else,
Yes.
we'll get to know only when the notification is placed before the
It's how
court.
we say it's court.
We want to see that notification. 6th,
6 months.
matter be listed on 6th, enabling the Learned Standing Council Cooperation Department to place the notification before the court, whereby the department has authorized the what secretary
My
deputy?
lord, the power of the register is delegated to additional register
Whereby
BTC.
the power of the registrar of cooperative societies have been delegated to
Additional register BTC.
additional registrar of cooperative societies, BTC. And as a consequence of any orders passed by the additional registrars, appeal thereto would lie only before the government,
State government.
state government.
Obliged.
List
Obliged.
on 6th.
6 months. Obliged.
May it please your lordship. Lordship, in this matter, my lord, the issue is very simple. The issue is such, my lord. I would like to take, my lord, page number 522, my lord.
Five
22. It's their affidavit, my lord.
First, you tell us.
Yes.
What is-
Because, my lord, the issue is this, they have accepted that they want to invoke
There
arbitration.
was an arbitration.
Yes, my lord.
agreement.
There was an arbitration clause.
Huh.
That is a clause 70. That is
Huh.
what I was coming to this letter, my lord. It's their affidavit in opposition.
Huh.
The issue is that whether they can univocally appoint an arbitrator, and that cannot be. And unilaterally, whether they can appoint an arbitrator.
Where is the agreement first?
Yes, my lord. The agreement is at my writ petition, the clause 70, my lord,
Page number?
391. My lord. Clause 70.
This is an agreement executed between?
Between, my lord, UPRNL and the army, headquarters, CC Army number 1, Dinjan.
Okay.
It's in regard to construction, my lord, of
Oh.
houses and buildings.
All right.
At clause 70, man.
Hmm.
All disputes between the parties to the contract, other than those for which the decision of the CWE, that is the chief wing engineer or any other person by the contract expressed to the final and binding, shall after written notice by either party of the contract to other of them be referred to the sole arbitrator of an engineer offered to be appointed by the authority mentioned in the tender document. And my lord, here the authority is chief engineer. Unless both party agree in writing, such reference shall not take place until after completion of alleged completion of work or termination or determination of contract under condition number 55, 56, 57 thereof. Provided that in the event of amendment of work or cancellation of the contract under clause 52, 53, 54 thereof, such reference shall not take place until alternative arrangements has been finalized by the government to get the works completed by or through any other contractor or contractors or agency or agencies. Provided always that the commencement or continuance of an arbitration proceeding hereunder or otherwise shall not in any matter mitigate against the government rights of recovery from the contractor as provided in clause 67 thereof. So, my lord,
Yes.
now I would like to take to the letter 520. Five, my lord, of the affidavit in opposition. That is their letter. Because here the clause is that whether there was completion of work, whether termination of work. Now they have admitted in their letter 25.
25.
In this connection, may I read, madam?
Hmm.
In this connection, please refer to HQ letter number so and so dated 4th May 2023, which is intimated to you that the arbitration referral may kindly be considered post completion of work under clause number 70 of so and so general conditions of contract.
What was your letter under reference?
The letter under reference is before that, is at page 31/12/2023, page 522. That is my invocation of arbitration clause.
Then?
We write in reference to the letter dated 20 August 2016, which was awarded to us for the work of provision of accommodation of certain units at Likabeli, Assam, and the CC Army number 1, Dinjan, with scope of work as construction of various buildings and structure for certain units and internal and external services. We say that CA amendment number 1 dated 18/2019 provides for dispute resolution board.
Your work was terminated.
My work was completed. After completion of work, the matter was referred to DRB. The DRB did not came up with a conclusion. As DRB did not came up with a conclusion, we referred the matter for, we wrote a letter for invocation of arbitration clause. The moment we referred the matter to arbitration clause, they came up with a reply on 22nd April 2024, 525, my lord. 525. It's their affidavit in opposition, my lord. In this refer your letter dated so and so dated 31st December 2023, which I just read out.
Yes.
Yes. In this connection, please refer to this headquarter letter dated 4th May 2023, copy enclosed, by which it was intimated to you that the arbitration referral may kindly be considered post completion of work under clause number 70. Now thereafter, my lord, we wrote a letter to them replying to their letter for the invocation of arbitration clause on 4/6/2024. That is at 526.
Yes.
In subject invocation of arbitration, we write in reference to the caption letter of award reference dated awarded UPRNL as contractor for.
Now what happened? They did not happen.
Yes, then my lord, their letter 529.
You proposed the names of arbitrators.
Yeah, we proposed
They did
that in
not
529, they said that work has been completed.
Hmm.
Then after the work has been completed, we wrote another letter that as the work has been completed and you have admitted to it, so please appoint an arbitrator. So please let us appoint an arbitrator, and we have given the names of arbitrator. Now what they reply is at 532. That's a letter, my lord. They want to unilaterally appoint arbitrator by their own, and we said you cannot do that. I have not given my waiver of section 12(5). At 7th August 2024, 532. May I read, my lord?
Yes.
Reference to your letter dated 16 July 2024. In this connection, your kind attention is kindly invited to condition 39.6 of DRB reproduced as under. If the decision of DRB is not the satisfaction of either party, or if the DRB fails to give decision within the laid down time, either party shall indicate his reservation of the decision to accepting officer within 30 days of such decision, and to referral the dispute of arbitration with the provision of condition 70 of the general conditions of contract. It is intimated that as per EBIT condition, either party must indicate the reservation on the decision to accepting officer with 30 days of such decision. However, your reservation protest to DRB decision was received by this office by your letter number dated 31st 2023, approx 18 months after the decision, therefore making it time barred. Notwithstanding the above condition 39.6.1 of DRB, in case of disagreement with the decision of such DRB, any party may invoke arbitration clause. and as per arbitration clause, condition 70, forming.
So you
part-
say under 12.5 it is barred.
Yes, I'm under 12, I'm saying it's barred.
Alright.
And they are accepting it that
What is the response of the respondents here? Yes, respondents.
Yes,
Arbitration council is for sole arbitrator.
yes,
Arbitration clause is for sole arbitrator.
yes, my lord.
Yes, ma'am.
So they have issued a notice
Yes, my lord.
calling upon you to concur on the name suggested.
Yes, my lord.
You do not concur, you appoint an arbitrator unilaterally.
No, my lord.
They'll have to give a waiver.
Yeah, my lord, what happened that the agreement has been amended, my lord, in that is in page number 511, paragraph number 3, my lord. Arbitration clause was amended, my lord. As per arbitration clause, they introduced dispute redressal board, my lord. And they present before dispute redressal before completion of work, my lord. Then, my lord.
When was the work completed?
No. Before completion of work, before that before the dispute redressal board, my lord. Not after
They
completion.
never completed.
Not completed, my lord.
The letter says so, we
My
have
lord, sir.
completed, my lord.
My lord, kindly see our letter dated 7th August 2024, page number 523, my lord. Everything has been described in this letter, my lord. May I read this letter, my lord? 532, my lord, page number.
532.
Yes, my lord.
Yes.
In this connection, your kind attention is kindly invited to condition 39.612 of the dispute redressal board reproduced as under. If the decision of dispute redressal is not satisfaction of either party, or if the DRB failed to give the decision within the laid down time, either the party shall indicate his reservation on the decision to accepting the officer within the 30 days of such decision, and to refer the dispute for the arbitration within a provision of the condition 70 of IAFW 2249 general condition of the contract. It is intimated that as per event condition, either party must indicate their reservation on the decision or to accepting the officer within the 30 days of such decision. However, your reservation protest to the DRB decision was received by this office by your letter number so and so dated 31st December 2023, approximately 18 months after the decision, therefore making it time bar. Now, my lord, not with understanding above the according to the condition 39.6.1 DRB, in case of disagreement with the decision of such DRB, any party may invoke the arbitration clause. And as per arbitration clause 70 of the IAFW 2249, formatting a part of the contract of the agreement. Unless both parties agreed in writing, such reference shall not take place until after the completion or alleged completion of the work. Since the work was still in progress in 2023, in 2023, he approached before the dispute redressal board, my lord. This headquarters so-and-so dated 22 April to intimated that the arbitration clause could not only be invoked only after completion of the work, my lord.
And the paragraph after that, my lord.
The subject work was completed on 10 May 2024. Thereafter, in response to your letter dated so-and-so, this headquarter letter number 19 June inform you that the case of our appointment of arbiter will be proceed under the condition of so-and-so. Upon receiving your confirmation that the claim referred to the during the DRB are final claim dispute in respect of the subjects here. Further, your kindly invite the then, my lord, what happened? Next, 17 August 2024, my lord. This is 7 August, my lord.
So the work was completed in May.
Yes, my lord.
24.
Yes, my lord.
And you served a notice in 23.
Yes, my lord.
No, my, we served
First
the,
notice in
we served the notice on 16/7/2024.
No.
Yes, my lord. The first notice we sent was on 4/6/2024.
Hmm.
Page 526, my lord.
522 is whose notice?
522 is my notice, but that was on invocation of arbitration because
Yes,
of the
my lord.
failure of DRB. Because of failure of DRB, that is
So
520.
on that day, the work was not completed.
Yes,
As per the contract.
yes.
Huh.
But thereafter, we wrote another letter on 4/6/2024 after completion of the work.
Where is that?
That is at 526.
526.
Yes.
Okay.
to which they replied on 19 June 2024. Four six 2024, sorry, not 5/6, 4/6 2024, 4th of June.
And then,
And then again, we wrote a letter for on 16/7/2024, replying to their letter. Once they agreed that we have completed the work and they're going to appoint an arbitrator. And on 7th August 2024, they said that my work is completed and now they are going to the E in charge, that is engineer in charge, is going to appoint a competent authority. For which we said that it cannot be. Because it's a unilateral appointment of yours cannot be because you're barred by under section
so
12(5).
now, either you agree, concur on the appointment of, on the names suggested by them, or we appoint it.
No, my lord.
Unless they waive. See, now there is no dispute that the work was completed.
Yes, no dispute.
Now, after the work being completed, the matter can be referred to arbitration.
Yes, my lord.
So they have issued a notice on 4/6/24.
Yes, my lord.
So in 4/6/24,
And
they
we-
have you given some names,
No, we had
No,
given a reference, no, we gave a reference to the letter,
earlier letter?
earlier letter.
All right.
We given a reference to earlier letter.
So you either agree on these names.
My lord,
The clause says only sole arbitrator.
yes, sole arbiter, my lord, here 4/6, they wrote a letter to us, my lord, regarding the invocation of arbitration clause. Then, my lord, in 19/6, we replied to that.
Saying
did.
what?
19/6, saying that the case for appointment of arbitrator from higher or headquarter will proceed upon receiving your confirmation, please.
What confirmation?
My lord, in connection with you, the earlier paragraph, my lord, in connection with under the reference letter, it is intimated that subject work has been completed. Consequently, the case of the appointment is being processed with E in C branch under
Now,
the.
under what provision are you making this demand? Is it a part of the contract? That after invocation,
No.
you will agree only after confirmation of the demands?
It is not.
Then it's nothing but dilatory tactic.
Absolutely, ma'am.
So you have entered into an agreement where arbitration is one of the dispute resolution, or is the only dispute or one of the dispute resolution. So what is to be done now? You agree on the names or we appoint an arbitrator?
My lord,
Yes, ma'am.
other suggestion, my lord may appoint. It will be better.
You have actually lost your power to now suggest a name after the mandatory period is over.
Court can appoint, my lord.
Of course, we can appoint, therefore we.
My lord, I have just a suggestion, my lord.
Hmm.
Because there's some taxation issue involved.
Hmm.
May Dr. Ashok Saraf, senior advocate, be
No.
appointed.
Because we will have to go by the notification.
Then, my lord, C.R. Sharma, my lord.
We'll decide.
My lord.
Heard learned counsel for the parties. This is an application under section 11(6) of the Arbitration and Conciliation Act 1996. The petitioner and the respondent. The petitioner was awarded a contract. Do you have a work order here?
Yes, ma'am.
Where is that?
My lord.
Yes, ma'am.
It is at, my lord, 19/1/2017, my lord.
Page number.
Index of, no, index to see.
Yes, yes. My lord. I apologize, my lord. It will be 20th August,
Page
2016,
number
page number 414.
414.
Yes, annexure 3.
Four one four is something else.
414, my lord. Uttar,
414.
yes, my lord.
414.
Yes, my lord.
It says something else.
Yes, my lord, will carry out, Uttar Pradesh version will carry out the undermentioned work at project manager as per the conditions provisions of accommodation of certain so and so.
This is the work order.
Yes, my lord, this is the work order. And the acceptance of it, the
It was given
Amit
the work
Katpatia,
order
Brigadier
by
Chief
or-
Engineer.
by communication dated 20 August 2016. For the so-and-so work, page number 414, bolded as this is the work. Date of handing over of the site and date of commencement of the work and completion of the work of different phases are clearly mentioned in the same communication stop. Thereafter, an agreement was executed by and between the petitioner and the respondent. There at clause 70, there is a clause for arbitration in cases of all disputes between the parties. Arbitration can be invoked after a written notice by either party to the contract for appointment of an arbitrator, sole arbitrator, of an engineer officer to be appointed by the authority mentioned in the tender documents. Stop. Thereafter, certain differences arose between the parties, and the petitioner invoked the arbitration clause by a notice
16/7/2024.
dated
4/6.
31/12,
Yeah,
2023,
Hmm.
whereby 3 names were proposed as sole arbitrators and inviting the respondents to concur on the suggestions made on any of the 3 names. Stop. The said notice calling upon the respondents was duly replied to by the respondents, stating that the arbitration is to be referred, arbitration may be resorted to only after completion of the work. And at the relevant point in time, the work was not completed, and therefore the provisions of clause 70 could not be invoked. Stop. Subsequent thereto, the petitioner completes the work on 10th of May 2024, and by notice dated 4/6/2024, the petitioner again calls upon the respondents to appoint an arbitrator by invoking clause 70 of the Arbitration and Conciliation Act, and a reference was also made to the earlier communication calling upon the respondents to concur on any of the names referred to in the first notice. The respondents, however, replied to the second notice calling upon the petitioner to intimating the petitioner that arbitration will be resorted to only upon receipt of confirmation from the petitioner that the claims raised are the final claims. Then what happens?
Then thereafter, my lord, they issued a letter. We again therefore replied to the letter on 16/7/2024, stating that no unilateral appointment cannot be done.
Where is that?
Page 530.
No, 532 is the subsequent
Yes,
letter.
yes.
Then
Then thereafter, my lord, they have been issuing letter for, but we have not replied to any of those letters.
5:30.
530.
thereafter, the respondent authorities have proceeded to appoint an arbitrator in terms of the clause number 70, and concurrence for the same was forwarded to the petitioner, which the petitioner, however, did not respond to. So, under such circumstances, the petitioner is before the court filing an application under section 11, praying for appointment of a sole arbitrator. Stop. The counsel for the petitioner submits that pursuant to the amendment brought into the statute in section 12(5), the appointment of the arbitrator by a respondent authority of an officer who falls within the specified categories in this schedule
Seven schedule, my lord.
seven
Section-
schedule
Section 12(5).
specify arbitration. Arbitration. Arbitration.
My lord, may I have?
We have the copy. Seven schedule as specified under section 12(5) are debarred from being appointed as an arbitrator unless there is a clear waiver given by the contractor. Stop. The petitioner has not consented to the proposal of the respondents, and considering the fact and therefore they are agreed that the proposal for appointment of an officer by the respondents cannot be accepted in view of the clear embargo under section 12(5) of the Arbitration and Conciliation Act. There are learned counsel for the parties have been heard, pleadings available on record have been carefully perused. There is no dispute that the arbitration clause at clause 70 proposes arbitration before a sole arbitrator in cases of disputes. First notice issued by the petitioner, although before completion of the work, contained 3 names suggested by the petitioner, which have not been concurred upon by the respondent. Stop. Subsequent thereto, the work was completed on 10th May 2024, which is not disputed by the respondent. Stop. The second notice was issued on
Second,
4th of June, 4/6.
4th June 2024, man.
Again calling upon the respondents to appoint an arbitrator. Stop. The respondents have failed to accede to the request made by the petitioner, and upon the petition being filed before the court under section 11 and notices being issued, and the respondent having failed to concur, they have lost their right to appoint their arbitrator. Stop. Consequently, the matter is before this court for appointment of a sole arbitrator in terms of section 70 of the arbitration. This court under the powers conferred under section 11 therefore proposes to appoint an arbitrator in terms of the notification number 29 dated 21st May 2024, whereby
My lord,
H.N. Sharma is.
Mr. H.N. Sharma?
Yes.
my lord, he's already occupied with arbitration.
Huh?
My lord, whatever.
H.N. Sharma be appointed as an arbitrator. Arbitrate and decide on the disputes arising by and between the parties. The proposed appointment will, however, be subject to the written declaration to be submitted by the prospective arbitrator as is required under section 12(1) of the Arbitration and Conciliation Act. There are let a copy of this order be marked to the proposed arbitrator and by the registry. The petitioner will also petition, the parties will also present before the arbitrator copies of this order, pursuant to which, upon receipt of the written declaration under section 12(1), the prospective of the proposed appointment will be confirmed. List this matter again on 27th of February.
Can it be, can we on 1st of March or something, my lord? On 27th?
6th of March.
My lord, also,
6th of March.
Hello. Item number 9, without a concern, I am waiting here.
No.
Yesterday also
Much
I
obliged, my lord.
prepared the brief. You should be at least informed.
It was mentioned,
Yes, without informing us, we are waiting for the case.
you get hold of the other side.
Or at least they should know the etiquette of the court.
They wanted to bring on record an affidavit filed today. So we thought it fit to have it listed on some other day.
11th,
What date? 11th.
they have not served the copy also. Always.
So let it be on 11th. Yes. Oof. Was I early?
No, my lord. Lordship is on time, my lord. My lord, on the earlier occasion, I have been asked to clarify some of the terms that were mentioned in the work order, my lord. The instruction I do have today. My lord.
You have.
Yes, my lord.
What is this apply?
The matter is about my refund of the chase amount, my lord.
Cess amount.
Chase amount that have been deducted by the APDCL, which has been remitted to the Labor Commissioner already.
AC টো লগাই থৈছে নেকি?
In this case, APDCL should also file an affidavit, my lord.
Who's for the petitioner?
So I think he was online.
Online. What is the
According to him, my lord,
Ah.
he is not liable to pay this cess, which has already been deducted by the APDCL. And according to the petitioner, his work was confined only with supply of materials, my lord. So according to him, my lord, he is not liable to pay any cess. Also, it was in the estimated cost, my lord. And it is reflected in the minutes of the meeting, my lord. Even the appeal provision is
What
also
does
there.
the provision of the act say?
My lord, if it is construction, my lord, so certainly, my lord, there are two parts.
এখন দিওকচোন। Building and Other Construction Workers Welfare Cess Act, 96.
First one, very different. Second different. Building and Other Construction Workers Regulation Employment and Condition Service Act 1996. And the Rule 1998.
Yes. They are supplier.
Yes,
They are suppliers.
my lord.
Where is it stated in the affidavit?
Yes. My lord, first of all, I am relying, my lord, clause, the APDCL floated tender on 13/2/2029, 19, my lord. That is annexed to page 30, my lord.
No, petitioner claims to be engaged in the business of manufacturing and
Yes.
distribution.
Yes, according to him, only he supplied and no other construction work he has done, my lord. My lord, but the, my lord, award of contract lordship will find, my lord, dated 24/10/2019.
Page number?
Annexure 3, page 33.
Award of contract.
Yes.
Execution of supply, construction and commission.
Commissioning of so and so, yes.
Construction also.
Yes, my lord.
So APDCL has deducted the cess
Yes, my lord.
payable.
1%
Uh,
out of,
You are for the state.
yes, I am for the state.
And there is
Leopard.
already this committee,
My lord.
there is a
Yes.
welfare board
Yes,
constituted.
yes. And my lord, your lordship will also see, my lord, the contract price, that is page 34, clause 30, 3.1, my lord. Erection part is there. First, A, supply part, B, erection part, my lord.
Yes.
And my lord, in fact, everything would have come clear, my lord, had the petitioner, my lord, informed accordingly pursuant to the notice that we have referred to in our affidavit, my lord. Lordship will find, my lord, first one.
Page 1
Page 118, lordship will find, my lord.
One five.
My lord. Sorry, 118, annexure 1 to the affidavit in opposition by the Liberton.
118.
My lord.
Yes.
Which reference the mention, you are hereby directed to submit necessary documents pertaining to the APDCL advanced metering project. The document, like the notice of commencement of work, relevant records relating to the payment made, which are essential for the purpose of assessment. You are also requested to submit the aforesaid document to the undersigned within 10 days from the date of issue of this letter. He has not submitted as yet, my lord. And thereafter, again, reminder was issued, that is page 120, my lord. Annexure 3, my lord. Please refer to the, till that no response has been, therefore. And now I am referring to Annexure 2, my lord, page 119. May I read it, my lord?
Yes.
The meeting was chaired by the Additional Labor Commissioner Assam. She also welcomed the members and provided a brief overview purpose of the meeting. The representative of from APDCL provides an update on the assumption of metering work across three regions: Upper Assam, Central Assam, and Lower Assam. In the Lower Assam region, Jenas Power Infrastructure Limited is a contractor working in 12 districts. Their responsibility includes supplying, metering, conducting two-phase and three-phase wiring, installing LT circuits, and performing LT metering. In addition to supplying of equipment, Jenas Power is also responsible for conditioning the system and handing over to APDCL upon completion. APDCL has clarified contract for the execution of supply, construction, and commissioning of distribution transformer metering in the Lower Assam region under this turnkey project. It was noted that taxes and duties would be deducted by the APDCL, with this cess being included in the estimated price within the package. So it is estimated price. Jenas Power has already accepted the terms and work which was initiated in 2019 and completed 2022. The project was finished and payments for the work were made accordingly. However, in 2024, Jenas Power submitted a letter stating that the project did not envisage any building or construction work and therefore is not liable to pay cess. The Standing Council emphasized that when the tender was awarded to Jenas Power, cess was already included in the estimated cost. It is further pointed out that under the Building and Other Construction Workers Cess Act, cess is applicable wherever construction worker involved. Additionally, the judgment of Honorable so-and-so supports this concept. It was decided that an assessment order be issued in accordance with the Supreme Court judgment so-and-so. Once the order is issued, it will be forwarded to the contractor for information.
Yes, what do you say, petitioner? You're representing the petitioner.
Connection issue.
Yes, Mr. Counsel. Yes. Well,
Number 8, my lord.
yes, please submit.
My lord, yeah.
Your contracts shows that its supply and construction and everything is included. So why are you taking the stand that it is only for supply?
My lord,
There's some problem with the connection. We'll try after a while. We'll try after a while. After a while, Mr. Goswami, let him reconnect and see. Please inform him.
my lord.
Wait for a while. You're
My lord.
not stable. Yes. This is the, what happened to the records?
Records I have, Your Lordship.
What does it show?
It shows, Your Lordship, on the last occasion, my learned friend has pointed out one thing, that how can the marks be given more than 5 when total mark was 15 in respect of the Viva voice. Now, in the earlier affidavit which I have submitted, I have filed, Your Lordship, that has not been clarified, that 15 marks for each member regarding the Viva voice, Your Lordship. So each member can give marks up to within 15 marks.
No, but in your, in some resolution, it must be adopted that how much of marks are to be allotted.
Yes, Your Lordship, yes.
Where is it available?
Resolution.
But in their affidavit, my lord, they have said specifically 15 marks for oral.
Lordship.
That does not indicate the each and member.
15 marks.
Yes, my lord, page 38.
You have not clarified on this statement.
Total. Page 38, my lord, first, second, third paragraph from the top. Page 38. Third paragraph from top. Total marks for peon in written test 30 and 15 for Viva Vosi.
It's a very clear averment.
Lordship. Otherwise, Your Lordship, it ought to have been 15 marks for each member of the selection committee, Your Lordship.
Who has filed that affidavit?
Then also, my lord will find at page 174. There are altogether 5 members. If 15 marks is taken, then 174. 1, 2, 3, 4, 5. Then total marks should be 75. As my learned friend is indicating.
How many members are there?
5 members.
1, 2, 3, 4, 5. Then it will be 75. Then how come they?
How come what?
How come they say, my lord, each member is allotted 15 marks? That it will not be, it will not come to 50 marks. It will be 75 marks. 7 into 15, my lord.
Where do they say the total marks?
Page 38, my lord. They have
38
filed in their affidavit, my lord.
38 written test is 35.
But written test
No,
is
35 is for the post of process server peon. Mine is next one, my lord.
30 plus 15.
30 plus 15.
Total marks is 45.
45. No, Viva Vosi, they have given maximum 50 marks to a candidate, whereas it is 15 marks. They have stated in their affidavit.
What about the PSP?
PSP, Your Lordship, as per my instruction, they have given out of 15 in respect of the Viva voice for each member.
How much?
15 marks for each member. Similarly, in respect of the peon also, I have the answers, mark sheets, wherein each member has been allotted 15 marks, out of which they have given to the candidates.
No, but then what will be your total mark? You are giving more marks in the Viva
Lordship.
than in the written test.
Yes, Lordship.
Written otherwise, out of 30, I have the answer, mark sheets, they have scored
No, but
within
can
30.
you do that?
Lordship.
Can you have more marks for Viva?
No, Your Lordship.
Then?
Now, if we calculate the average out of 5, it comes below 10, Your Lordship. 8 point something, 9 point something, it comes in that way, Your Lordship.
You have already enclosed this mark sheet,
Lordship.
compiled sheet.
That is the compiled sheet, Your Lordship.
There are 5 members, Mr. Chakraborty.
Yes, my lord.
Now, if you have to go by the statement at page 38,
Yes, my lord.
it is 15 marks.
15 marks.
Now, if 15 marks means it will be 3 marks
3 marks for each member.
per member.
Huh.
So if it is 3 marks, then this is not applicable. This 174 doesn't tally with that.
Which one, my lord?
If you read the total marks.
Yes, my lord.
As 15. 15,
Into 5. Sorry,
no, 15 total
total,
means there are 5 members.
5 members.
So
Then also, my lord, kindly see the marks allotted. How can they give beyond 5? 11, 10, 9, 9, 7, 6.
that's what we are saying.
Yes, my lord.
The interpretation which you have given that the total marks is only 15.
Yes, my lord.
You can't go beyond 15.
Yeah.
Now, what is the meaning of that?
Total marks for written test is, my lord, 15. Sorry,
written is
Viva
30.
Viva
How
was
do
15.
how do you understand that?
Well, maximum any member can give not my lord, more than total more than 15 marks, my lord.
15 marks.
Yes.
So which means each member has the is allotted to a maximum of 15 marks.
Yes, my lord.
Isn't it? Each member. Right?
Yes.
So they have given these marks accordingly.
And as per their statement in the affidavit, my lord, it should exceed 15 marks per candidate. And my lord, total marks, then what would be the marks for written test, my lord? 30.
We do you explain us how
Yes,
to
my lord.
Lordship,
read the markings.
Lordship. Lordship, each member has been allotted 15 marks.
So first you tell us what is the meaning of the statements at page 38.
Page 38, Your Lordship, out of 30 marks, the written test has been conducted. That apart, the Viva voice, it was written as 15 marks, but it ought to have been 15 marks each member, Your Lordship.
All right.
And I have already, in my additional affidavit, I have already brought on record the compiled result sheets. Apart from that, I have the result sheets that has been given by each and every member, Your Lordship. On details.
What is the judgment where you can't give more marks?
Yes,
in
there
type?
are, but I have not got that judgment. my lord.
Here, Your Lordship, if we see Your Lordship, personality maximum mark is 5, behavior maximum mark 5, intelligence maximum mark 5. Total marks obtained out of 15. Now, roll number 38 is the private respondent and roll number 60 is the petitioner. Similarly, based on this calculation, the consolidated results for Viva voice has been declared, Your Lordship, which is already on record.
Yes, my lord has rightly pointed out that, my lord, Viva voce cannot be more than written test, my lord. There are judgment, but and they have not explained also here, my lord, simply said 15 marks. They did not say 15 marks for each member. Simply said 30 marks for written test and 15 marks. We have to understand that way maximum 15 marks can be allotted to one candidate.
And out of all these, what do? You take out the average.
Average, Your Lordship. Because total 15 marks, then if we divide by 5, it comes 3, Your Lordship.
No, then it is permissible.
Huh?
Then it is permissible.
No, my lord, may not be.
Because if we get the average, Your Lordship, roll number 60, he scored 8.2 marks in the Viva voice. If we divide it by 5. And roll number 38, that is the private
Permissible.
respondent, he scored 9.8.
Your grievance was essentially that uh, the roll numbers were exchanged.
Actually, roll number 38 appeared as a general candidate, but he was given appointment in a reserve category candidate. Then, my lord, I stated in my affidavit in reply that when the my candidate went to put his signature in the vibavosi test, he did not found the roll number, put his signature in the reserve category and such attendance sheet. Then my lord directed them to produce the attendance sheet. They said, no, we did not maintain
they don't
any.
have.
Then, my lord, they said they have issued call letters to them, whereas in the call letter itself, separate call letters they have issued. But in the call letter itself said no separate call letters will be issued. Candidates will have to bring that call letter along with the, which was issued to them earlier during the vibavosi. My lord, in paragraph 6 of that page, my lord, can you see? Page.
No, I don't think we don't find any infirmity that way.
Paragraph 6, my lord. Page
Paragraph 6 of
156.
what? Of,
Page 156, they file an additional rejoinder affidavit, my lord. 156. Paragraph 6, my lord. The answering deponent further states that based on the corrigendum dated so and so, the selected candidate in the written test for the post of process server were called for in the vibavosi test. It is pertinent to mention here that there are no separate register being maintained by the selection committee board or vibavosi. Registers are maintained for the written test only. For vibavosi test, the board has sent call letters to the selected candidates. Accordingly, vibavosi test was held. Whereas, my lord, will kindly see at page 16. In the call letter itself, they say no separate call letters will be issued.
How does it affect you?
And my lord, it is not verified. And on the basis of what, my lord, kindly see in the.
No, how does it affect you?
My lord?
How does it affect you?
Because, my lord, in their contradictory statement, my lord. In the call letters, they said no
This
separate.
attendance sheet is for what? Written test.
Written test. This is for written test. They have maintained also, though they are denying, my lord.
That you don't have a copy.
Which one, my lord?
This is by the respondents.
Respondent.
This is enclosed by the respondents.
Yes, my lord.
All right. Then
And my lord has rightly said, how can they be vibavosi test be 75 as against?
No, because they're taking the mean.
They have not given this explanation in their affidavit. Now they have changed their stand, my lord.
So they may not have given, but if you look into the marks at
Yes.
page number 174.
Yes, I have seen, my lord.
So it doesn't exceed the amount, no? Doesn't exceed the total marks.
No, that is different, my lord.
Divide them five.
Doesn't exceed the
No, no,
total marks.
In fact, Lordship, I have the mark sheets of the written test also. Which candidate have scored what marks, Your Lordship.
This 174 is what?
174 is the compiled result of the Viva voice, Your Lordship.
Only Viva.
Only Viva. Now, regarding the written test, I have the mark sheets, the marks obtained by the candidates, Your Lordship, out of 30.
How many these members were there?
5 members.
5.
Now you tell us what is the marks as per these persons who have received. This is Viva Bosi.
Hi, Babu.
We gave it to Newton, I think.
I have a copy also.
So Viva Bosi, one member has given 11,
11,
then 10, then 9, then 9,
10, then 9,
9,
then again 9, then 10.
10. Total is 49.
49. Now 49, if we divide by 5, it comes 9.8, Your Lordship.
So where have you recorded that?
No, no
Where-
recording, nothing.
Huh?
No.
That has not been recorded here, but otherwise the calculation has been done in that.
Where?
It has been, otherwise the record does not reveal source, Your Lordship.
Then from where are you making all these statements?
Yes, my lord, how, we have to understand that how these marks are given.
But otherwise, as per the instruction, it has been divided by
When was
5,
this election made?
2014.
14, Lordship.
What is your prayer now?
My lord, actually, there is one judgment also, my lord, if the, with regard to, my prayer is, my lord, that it is a settled legal proposition that if an order is bad in its abstention, it does not get sanctified at a later stage. A subsequent
No,
action.
no, that we have understood. What
Yes,
is
my
your
lord.
prayer in the writ
A
petition?
prayer, my lord, to set aside the appointment of the
And
respondent,
then what happens?
my lord. My case may be considered.
How
Prayer-
can it be done today after 12 years?
Page 10, my prayer is at page 10.
How can it be done after 12 years? The respondent's appointment alone cannot be set aside. You'll have to interfere with the entire selection.
Yes, my lord.
Then your prayer is for setting aside on the ground that a general category has been appointed against a reserved category.
Yes, my lord.
That they have explained. Now on the question of selection,
Yes, my lord.
you want interference. Now interference alone will not do. This post will again have to be advertised.
Yes, my lord.
Or the selection will have to be done again.
Yes, my lord.
Then after 12 years, the rest of the people must be working this.
Yeah, yes,
They
they are
are
working.
working.
Then what other reliefs can the court give you? It's too late in a day.
My lord.
It's too late in a day.
And some
Without-
compensation, my lord.
What compensation? We can at best give you the cost of litigation. That's all. You tell us, you think about it,
Yes.
tell us if there is any other.
Can
prayer
it be,
that-
my lord, you take it up on Friday. I will not take much time on that.
Friday. Let's pray it for.
All right.
Take a matter, Mati Duflu is available. Line. Yes, Mr. Goel, tell us.
My lord, if my lords allow, my lord, giving a short background of the case, my lord. It's a fresh writ petition, my lord, seeking the illegal deduction of the labor cess. My lords, I'm seeking this relief, my lords, under the garb of BOCW Act, which is especially for the labor cess and applicable on the civil supply construction, my lords. My lords, my case here completely rely on the Supreme Court judgment, which was been passed in 21. My lord,
First,
this-
let us facts. Mr. Goel, let us understand the facts.
my lord.
Where is the award of contract?
My lords, so we see Annexure 2, and Annexure 3, my lords, page number 28 and 29, and LOA, my lords, page number 33. My lords, Annexure 2, that is the e-tender, my lords, that was been allocated to us, confining our scope of work, which was been defined. Subsequently, in LOA, if we see, my lords, page number 33.
Yes.
My lords.
This is for execution of supply, construction, commissioning.
My lords, though my lords, it's completely interpretation of words. My lords, my scope of service defined later under LOA. It's something which is, my lords, allow me a minute. I'm just coming to the right paragraph. My lords, we see award of contract and its scope, that is on page number 33. And again, my lords, my scope of service completely depends on the contract price, which is again defined under page number 34. If we see, my lords, contract price and the scope of service, that is specifically clear in LOA, page number 33 and 34, my lords. But it says that, if my lords allow, I read the paragraphs.
Read it.
My lords, my lord, award of contract and its scope. We confirm having accepted your bid referred to at paragraph 1.3, 1.3.2 in conjunction with all the specification terms and conditions of the bidding document and award on the contract for the complete execution of the proposed work against APDCT Pact of DDUGY in Kamru. My lords, this is something I place where the this execution was been happened. Again, my lords, coming on the second paragraph 2.1, 3PH 4-wire LT metering of existing distribution transformer with necessary accessories. The circle-wise, district-wise breakup of DTR metering works to be executed is enclosed as Annexure 1. My lords, again 2.1.2. The execution of supply, construction, commissioning of distributing transformer metering in LAR under this package is to be undertaken under particular scheme. Hence, utmost care should be taken during execution so that work of this package does not over.
Mr. Counsel, you are claim that you are not liable to pay the cess because it is only a contract for supply.
My lords,
Is that your case?
this is my case, though this is a little differ.
Work order shows it is on a turnkey basis for supply, construction, commissioning of the transformation distribution transformers.
My lords,
it is only for supply.
My lords, again, my lords, this is something a scope. Again, my lord, what my first submission is interpretation of words. My scope of service completely defined, particularly later come under LOA, where my scope of service and contract price was being mentioned. Here, my lords, if we see contract price, where I am charging for my services, and I am charging for my services, my lords, page number 34.
First, let us understand what is your contract. Is it only for supply or it is a turnkey project including supply and erection?
My lords, my project is composite project. My lords, it's for the supply and erection. Though supply and erection not coming under BOCW Act. If my lords allow, my lords, please. My lords, if we see BOCW Act definition clause, section 2, subclause D. My lords, if we see the definition clause of building or other construction work, which is specifically clear, that means the construction, alteration, repairs, maintenance or demolition of or in relation to building, streets, road, railways, tramways, airfield, irrigation, drainage, embankment and navigation works, flood control work, generation, transmission, distribution of power, water works, oil and gas installation, electric lines, wireless.
Come to the definition of contractor. Who is a contractor?
Well, again, coming on contractor part, that interrelated in between contractor and employer. What is C, my lords? Definition of contractor means a person who undertakes to produce a given result for any establishment other than a mere supply of goods or article of manufacture by employment of building workers or who supply building workers for any work of the establishment and include a subcontractor. Now, my lords, coming on the definition clause of employer, that is subclause I. In relation to an establishment mean the honor thereof and includes in relation to building or other construction work carried on by or under the authority of any department of the government directly without any contractor. The authority is specified in this behalf or where no authority is specified, the head of the department. Again, my lords, point 2 of this clause. In relation to a building or other construction work carried on by or on behalf of local authority or other establishment directly without any contractor, the chief executing officer of that authority or establishment. So, my lords, if we see both definitions, here, my lords, I am not employer. Coming on contractor part, my lords, it specify that when contractor, the scope of contractor defines specifically on the assignments which come under definition clause of subclause D. Now, my lords, I am relying on Supreme Court judgment. If my lords allow, page number, annexure 5, my lords, page number 90, paragraph 54, my lords, 51 and 52, my lords. The solely, this liquidation depends, rely on this Supreme Court judgment, my lords. Thereafter only the scope and window comes to alleging the labor cess deduction on supply and erection. My lords, paragraph 51, page number 90, my lords.
Yes.
My lords, if my lords allow 51, 52, 53, all are relevant paragraphs of this judgment. My lords, I'm reading para to para. This paragraph 51, the clear statutory scheme of the BOCW Act excludes a supply contract from within its ambit. On behalf of respondent 1, it is pointed out that several public authorities and complainants such as Delhi Metro Railway Construction and Karnataka Power Transmission Corporation Limited have issued instruction that no cess under BOCW Act is leviable on a contract for supply of goods. Copy of KPTCL circular dated 22 of August 2012 and 28 of August 2012 to this effect as annexed.
To understand how you consider yourself to be a mere supplier of goods, when the work order itself says it is a turnkey project.
Malad, as per this judgment, it's very clear that the scope of services, if it includes construction part, then Malad, supply and erection can be divisible. As per this judgment, it's not solely like if my scope of service includes supply and construction, then the labor is applicable on the construction part, but not on the supply and erection. Here in this case, my lords, I am stating that there is no activity on construction. Again, my lords,
Where is the finding of the apex court that in a composite contract of supply and erection, supply is to be excluded? Which paragraph?
My lords, paragraph 53.
Five, 3.
53. Page number 90, my lords.
Yes, 91.
91, my lords.
Which paragraph?
My lords, paragraph 53, my lords.
53. 53.
53, my lords. 53.
53 is 90.
Page number 90, my lords.
Yes, what do you say with regard to the judgment referred here, Mr. Goswami?
Yes, my lord. That 90, my lord.
64.
This. May I read this one once again? That is paragraph 53, madam.
53.
Of, as referred to my learned friend, madam.
Yes.
Says under the act, read which POCW Act is leviable in respect of building and other construction works. This is admittedly no building, but other construction work. The condition precedent for imposing of cess under the cess act is the construction, repair, demolition, maintenance, and or relation to a building and any other work of construction, transmission towers in relation to other inter alia to generation, transmission, and power distribution of power, electric lines, pipeline, etc. Mere installation and erection of pipeline equipment for generation or transmission, distribution power, electric wires, transmission towers, etc., which do not involve construction. These are not included by you. We also admit these are not included, but other things are included, dear my lord, because lordship clause
No.
3.1.
Read this paragraph carefully.
Yes, mere installation and or erection of pipeline equipment for generation or in transmission or distribution of power, electric wires, transmission towers, etc., which do not involve construction works are not amenable to cess under this cess act. Yes.
So what is the meaning of that?
According to the intimation, accordingly, no intimation or so and so and so. Yes, this is admitted position that mere installation and or erection of pipelines equipments are transmission towers which do not involve any construction. But your lordship will kindly see clause 3.1, madam.
No.
This
Tell
is
us what is
survey, planning, design, engineering, assembly, manufacturing, testing, supply, transportation. Some of them are not, my lord, cannot be 3.1, my lord. Clause 3.1. My lord.
Oh?
That is, my lord, page 33, my lord. Scope of the work.
No. Subject to correction, if I've understood, the counsel for the petitioner is relying on para 53 to say that even installation, erection of pipelines and equipments of generation are not construction work.
Yes. According
Therefore, this is his contract.
My lord.
Although you have used the word of supply and erection and turnkey, essentially what he's doing is he's only, there is no construction work involved. That is his interpretation.
My lord.
What do you say?
No, that is why I am referring to that, my lord. That 2.1.2. Lordship will page 34, my lord. Clause 2.1.2. Also, my lord.
34.
Yes, my lord. I'm referring, that is.
Yes.
Yes. The execution of supply, construction and commissioning of distribution, transformer, metering in LAR under the package is to be undertaken under so-and-so scheme, hence utmost care should so-and-so. Next, the submission of initial survey report proposed to be metered for the project area so-and-so. The scope of the work under this letter of award shall also include all items which are not specifically mentioned in the bidding documents and or your bid are necessary for successful completion of your scope and under the contract for execution of the individual so in the project unless otherwise specifically excluded in the bidding documents or in the LOA. And my lord, the contract price that has been referred to 3-1, my lord. The
No, no.
total contract price of the,
Mr. Council,
My
please come back to para 53.
yes, yes. Yes, my lord.
So relying on 53,
My lord. Mere
it's an
installation and
interpretation
erection
by
of
the
pipeline
Code.
equipments. My lord,
Then-
that I understood, my lord. Mere installation and equipment of
Is not
erection of
construction.
pipeline equipments for generation or transmission, distribution, power, erection, so and so, which do not involve construction work. These are not involved, my lord. Apart from that, other things are here included, my lord. That is why I am referring to all these things, my lord. That is my respectful submission.
No, no, no. If I have understood para 53 correctly, it
My-
means
my-
that work of construction, transmission towers, etc.,
My lord,
cannot be construed to be construction where there is mere installation
my lord.
or erection of pipelines, equipment for generation, transmission, distribution of power, electric
Yes,
transmission towers,
yes.
which do not involve construction work are not amenable to
Right.
six. Now, the contract which you have given him is for erection of what is that transformer.
Smart meters, my lords. For the smart meters, my lord, we will
And
see
my
page
lord,
number
other-
49.
That is why, my
It's
lord.
it's something supply of a smart meters, my lords. It's also clear and specify in page number 49. If we see page number 49, my lords, the
No, no.
scope of service been defined.
Does it include construction work?
No, my lords, again, that's the
My lord.
What is claiming?
That is his claim, my lord.
Oh.
But as per the minutes of the meeting, my lord, which
No,
has been,
That is
which-
not only his claim.
My-
His claim is based on the interpretation given in para 53.
yes, yes. But all this, which I have referred to, my lord, that is clause 3-1, survey, planning, design, engineering, assembly, manufacturing, testing. These are also included there, my lord.
No. See, I am coming back to 53 again.
My lord.
As 53
My lord,
exclude certain items
yes,
from the term construction work.
my lord, right,
If so, what are these items?
my lord.
Number two is if these are excluded, whether the works undertaken by the petitioner
My lord.
fall within these excluded items.
Yes, my respectful submission in this regard, my lord. The area of work that has been referred to in this Supreme Court judgment, my lord, that will not cover everything, my lord. That is, your lordship will find at page 33.
You are entitled to argue that, but these are judgments of the Supreme Court binding on us.
Yes,
This
certainly
interpretation is
binding. So far, supply parties, my party is concerned, my lord.
No, 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 not mere
And
supply.
connected
No,
with
no.
this, my lord.
You read para 53, therefore
Yes,
we are asking you over and over again to go through para
yes,
53.
yes. And,
It is
and my
not
lord,
just-
for the
it is not
timing
just
only, my lord.
supply.
Yes,
It is installation,
yes,
erection of pipelines,
yes,
equipment for generation, transmission,
Yes.
distribution of so and so, which do not involve construction work.
yes.
Now you have to define what is construction work.
Yes, my lord. Your lordship will kindly see clause 3-1, my lord.
Of
Page 30, my lord, annexure 2.
Yes.
3-1, my lord.
Hmm.
The scope of work under the subject package includes site survey, planning, design engineering, assembly manufacturing, testing, supply, loading, transportation. These are from loading, transportation, unloading. These are not included, my lord. But first part, your lordship will see includes survey, planning, design, engineering, assembly, manufacturing, etc. This is,
Provided it is a construction work,
my lord.
as
That-
per,
that
as
is why,
per
my
the
lord.
interpretation given by the apex court.
My lord, directly, it is not defined, my lord. These are not the construction work, my lord. That is not there, my lord.
Then you'll have to ask your junior colleague to put in some more labor to find out what are the subsequent judgments, if
Fine.
any?
Fine. No, I am only referring to, my lord, the
No,
provision
see,
of the.
there is no scope for the court to interpret
My
a
lord.
judgment of
No,
the
no,
apex
no,
court.
that part, my lord.
So
That
therefore,
part,
if the
so
apex
far,
court,
that is concerned, my
apex
lord.
court has held that these are works excluded out of the construction work,
My,
we'll have to accept it.
my lord, that part, certainly, we are bound by that judgment. my lord.
So
We
if
are
you are
bound.
bound, then
And my respectful submission is not in the judgment, this survey, planning, design, engineering,
it
assembly.
is not included, but the exclusion part is only construction work.
Yes.
You will have to say that these design, survey, planning, design are part of construction work.
No, all these things are not there in this judgment, my lord.
No. But from your records,
My lord.
you have to show that these are part of construction.
Yes.
Therefore, the petitioner is not
My
included.
respectful submission in this regard is the petitioner accept referring the judgment of the Supreme Court, my lord. Factually, nothing has been he stated, my lord.
Nothing.
That I have
So-
not done, I
so
have
he
not
is- he
executed
relied
any
on-
construction
he
work, my
relied
lord.
only on para 53.
My lord,
So it is for you
my lord,
and the APDCL
my lord.
to come up together and apprise the
Charging
court.
charging
Judgment
charging
because of XYZ reason.
No, judgment is applicable, but other part of the work, my lord, which I have referred to, that is my respectful submission.
No, what you're saying is that judgment is applicable, but in part,
My lord, yes.
not
Yes,
entirely
yes.
applicable.
No, yes,
So that area which according to you is not applicable,
my lord,
you'll have to give it by way of records.
my lord.
Or if you'd like to rely on some other judgments to show that this
Yes.
has been further referred to and clarified.
My lord.
Right, heard Mr. Goel.
Mr.
The-
Prerit Goel, sir.
To the petitioner, Mr. D. Goswami, additional AG for the state, Mr. B. Das appearing for the APTCL.
My lords, apologies, my lords, but in support of my claim, my lords, I already placed number of judgments which is stating and addressing the same judgment, my lords, and clarify the definition of employer, contractor.
Where are the judgments? Not here.
My lords, already placed. Just because my lords, arguments done, and I filed a written submission along with the number of judgments, my lords. So I just convey to my colleague.
Mr. Counsel, are you submitting this matter was argued before some other bench?
My lords, it's already argued.
Why did you submit it instead of allowing us to go through this?
Was submitted in code number 18, your lordship.
How am I supposed to know that?
At that time,
How am I supposed to know that unless you apprise the court?
I apologize, your lordship.
You have taken more than half an hour's time to hear a matter which according to you, you have argued before some other court.
I like to point out also, my lord.
So, my lords, one last point, my lords. Since
Everything, my lord. Had the petitioner submitted all information as sought for as appeared, my lord, annexure 1, page 118 of the affidavit in opposition, everything would have been clear, my lord.
No, Mr. Counsel, why don't you understand it?
My lord.
You have given
Yes,
him
yes.
a contract,
My lord.
award.
My lord.
This award defines
Right.
supply, construction, this, that. The Supreme Court definition Supreme Court interpretation at 53 has clearly identified certain works which, if it does not include construction work, are excluded.
My lord.
Now, according to him, it doesn't include construction work. What further evidence will he show? It is for you to show
My lord, yes.
that these work are excluded out of the definition of the
Yes.
interpretation given by the apex court
My lord.
because it includes construction work.
My lord.
He will obviously not come out with any materials because the judgment is in his favor. If
No,
you
that
want to
part-
distinguish
that,
it,
On the first day itself, my respectful submission was so far supply part and connected to work is concerned, my lord, that is not covered. That was my submission also. my lord.
all right, heard counsel for parties. Although this matter was stated to have been urged before some other court, no such submission was made until the matter was argued before this court. There's no indication in any of the order sheet that the matter was heard and or end of legal or final hearing was undertaken before the court. counsel for the petitioner also submits that he had made submissions of written arguments along with the judgments he is relied upon, which however are not available in the case record. Therefore, save and accept the judgment of UP Power Transmission, which the counsel for the petitioner has pressed into service in support of his contentions. Stop. The pleadings, although complete, pleadings are complete. Therefore, the matter is kept for further hearing on, give us a date.
As your lordship.
Oh. On 17th February for further hearing. Heard in part. And
Hello.
parties are permitted to submit the list of judgments which they seek to rely upon.
My lords. Much obliged, my lords.
Please take out again.
My lord, this is for the appointment of arbitrator. And the arbitration clause is available at page 55, my lord.
Any objections?
Lordship, yes, there is an objection, your lordship.
What?
Because lordship, there is a clause, there is a pre-arbitral condition, your lordship. Page, your lordship.
64, 65.
No, my lord, this
Page,
is the
page
Central
50,
Public
page
Wa-
55, your lordship.
55.
Yes, lordship, clause 25. This is a condition, your lordship, that before lordship, invoking your lordship arbitration, they has to go through this was the clause 25, your lordship. There is a your lordship, DRC called this dispute redressal committee. They have to place their grievance before the DRC.
Has it been done?
Not been
Yes.
done, not been, not lordship, not been done,
Not done.
not done, your lordship. Their grievance is that we have failed to constitute the DRC in a prescribed period of time, your lordship.
What is the value of the amount? Value of the
Here, they, my lord, the sole arbitrator will be appointed. Value is lesser than that.
below 20.
Yes.
So, where is the dispute resolution?
The clause 25.
Who
your
is
lordship.
supposed to refer it to dispute resolution?
The
Does
chief
it-
engineer, my lord.
Chief engineer and two other government
And now
members.
time is prescribed. They fail to act as required under the agreement.
No,
Second chance cannot be given. It is well settled law.
no, lordship. No, lordship. Lordship, page 102, annexure 33, your lordship.
102.
Yes, lordship.
Where is
Page
it?
1. Read petition, lordship. Annexure 32, your lordship.
Yes.
This is the letter, your lordship, 15/11/22. They have wrote a letter to us, your lordship, and they're asking us to place their grievance before your lordship, DRC. And within 15 days, your lordship, from the date of receipt of the letter, within 15 days, we have to place their grievance before the DRC, your lordship. Then said letter has been received, your lordship. Lordship, next page, 108, your lordship, annexure 33. This is the letter, received letter. May I read, your lordship? With reference to the above cited subject, it is stated that the letter under reference is received in this office of 30/11/22. From the date of 30/11/22, within 15 days, we have to constitute our DRC and place his lordship grievance, your lordship. And your lordship, and date has been started from 30/11/2022, lordship. And lordship, next, your lordship, annexure 36, page 112, your lordship. The 14/12/22, we have constituted our DRC and asking him to place here grievance before the DRC, your lordship, within 15 days, your lordship. This is the mandatory period of 15 days.
No, the 109 is seeking consent for change in the constitution.
Yes.
No, lordship, this is, no,
No.
lordship.
109. Change in the constitution of DRC.
Yes,
No,
DRC,
no,
instead
lordship.
of
No,
appointing.
lordship, kindly, lordship, kindly have a look on lordship, page 112, your lordship, kindly.
112.
Your lordship, annexure 36, your lordship.
Yes.
This is the letter, your lordship, and we have 14/12/22. Within these 15 days, we have considered DRC.
But then what happened?
What happened? They have not placed their demands, your lordship,
This is on 17, my lord.
within
not
the
14.
15 days, your lordship.
Now, this
And
was,
their grievances that, your lordship, we have failed to consider the DS in the prescribed period of
This
15
is
days.
14 or 17?
This is the 14, 12, 22. Before
Annexure 30,
1 day left, your lordship.
14, 12?
Yes,
after
lordship, 14,
15
12.
days.
No,
No, for 15 days,
date
your
of
lordship.
receipt is 30/11.
Uh,
So 15 days is 15/12.
15, 12.
It
lordship.
was received later on, my lord. I am coming to that. Page
Where is that contract provision again?
36.
Yeah, start from 50 to your lordship. And your lordship.
Seventeen twelve, my lord. What he, my learner brother is reading, this is not the 1412. This is 1712.
No, this is 14, 12, your lordship.
We have already,
14, 12, lordship.
No, you said 15 days from the date of receipt.
Receive, lordship.
Where? Under which clause?
Clause 25, your lordship.
Read it.
Yes, lordship. Page 55, your lordship, clause 25. Except where otherwise provided in the contract, all questions are and disputes relating to twin meaning of the specification, design, drawing, and instructions herein before mentioned, and as to the quality of workmanship or materials used on the work, or as to any other question, claim, right, matter or thing whatsoever in any way arising out of or relating to the contract, design, drawing, specification, estimates, instructions, other or these condition or otherwise concerning the works or the execution or failure of the execute, the same whether arising during the progress of the work or after the cancellation, termination, completion of abandonment thereof shall be dealt with the mentioned herein after the contract consider any work demanded of him to the outside of the requirement of the contract, or dispute and drawings, records, or decision given in the writing by the engineer in chief or if the engineer in chief consider any act or decision of the contract or any matter in connection with or arising out of the contract or carrying out of the work of the unacceptable and is disputed, such party shall promptly, within 15 days of the arising of the disputes, request the chief engineer / CPM, or where there is no chief engineer / CPM, requested the additional director general / special director general, who shall refer the dispute redressal committee. Within 15 days, along with a list of disputes with amount claimed, if any, in respect of each such disputes.
So 15 days,
Yes,
it doesn't say 15 days from the date of receipt.
Yes, sir, from date of receipt of that letter.
How? Where? From which clause? Within 15 days.
Yes, Lordship, within 15 days,
So,
they have requested as to the 15/11/22. That same letter has been received on 30/11/22. Within 15 days. Then may I read
and
letter?
otherwise also, my lord, DRC is not mandatory. Numerous judgments are there. When the arbitration clause is there, main thing is the arbitration. DRC is the concern, this is the adjudicated process, in-house adjudicated process, which is not binding upon the parties also.
no, this is a contract entered into you by you
Lordship,
only.
Yes, Lordship.
Yes,
He's
Then
the signatory of this
so
contract.
I am, but I have.
you have also entered into come to 2 paragraphs below.
Yes, Lordship.
You see, it is a clear mandate that this party seeking, invoking arbitration must exhaust
Yes, Lordship.
But
They can-
but it is not mandatory in view of the law laid down by the honorable.
Let us see. Was this contract under consideration?
Once they received the notice, they wanted the rewriting the contract, which we declined. So they waive their right. Paragraph 18, my lord. In numerous judicial precedents, this court has taken the view that any precondition in an arbitration agreement oblige one of the contracting parties to either exhaust for pre-arbitral amicable resolution avenue or to take recourse to the conciliation are directory and not mandatory. And second, my lord, submission is that they terminated the contract. So once the contract is terminated, all the terms and conditions of the contract got perished, except the arbitration clause, because it is protected by the section 16 of the Arbitration and Conciliation Act. Arbitration and Conciliation Act says, my lord,
When was it terminated?
16/8/22.
Before you raised the claim?
after termination, my lord.
Huh?
Contract was terminated on 16/8/2022.
Page number?
Page number 82, my lord. And before termination, they should have approached the DRC. They are going, because DRC is for both the parties.
82.
Page 82, my lord. They themselves have violated the DRC. Page 82 and
When did
actual.
you raise your this demand for dispute resolution?
15/11.
Page number?
15/11/22.
Page number?
Page number, this,
102, Lordship.
just 55,
55.
55.
No, no, no. This is the clause.
Clause, yes.
Is your application for placing it before DRC.
DRC, yes. This,
There's a 102 page.
page 102.
15/11/22. They have raised that claim before DRC, Lordship.
102. From 15/11, they should have appointed within 15 days, the DRC. Now,
All right, we'll continue on day after. Let us find out.
Lordship, next week, Lordship.
Day after.
Lordship, next week,
No, next week.
next Tuesday, Lordship.
No, 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 day after.
they,
For
Court case.
further hearing day after. Mr. Hussain for the petitioner and Mr. Mehdi for
Yes,
the
sir.
respondents. Day after, day after.
Lordship, next Tuesday, Lordship.
May please the lordship.
Hmm.
My lord, here in this case, the petitioner's land was taken for construction of roads under Assam Mela scheme. My lord, there has been gross violation of the procedure in taking their land, my lord.
Hmm.
And there is an order of this on court on 24/9/2025. My lord, asking the other side to appraise this on court under what provision of law the subject
land,
one minute. একটু এই সন্দীপন অপূর্ব এই দুটা প্রিন্ট আউট করে তো তার লাগে এই গুগল ড্রাইভার আছে জানে
my lord. My lord, there is an order dated 24/9/2025.
Yes, yes.
My lord, on that day, my lord, matter was heard and this honorable court has asked the other side, under what provisions of law the land was taken, land was acquired, and they are to apprise the honorable, this honorable court to, in this regard, my lord. On 24/9/2025.
Then
24/9/2025.
thereafter
My lord, thereafter, my lord, they are taking adjournment, my lord. And in the next day, my lord, also they have taken at last date, my lord, on
yes.
4th.
What do you say?
Lordship, regarding the project, the Assam Mala project, that is the project implemented by the state government for widening of the roads in Haflong, Lordship. Although we have acquired the land, regarding acquisition of the land, we have already paid the compensation to all the petitioners that we have already filed in our affidavit, Lordship, which we have filed, Lordship. The affidavit, it reflects that we have already transferred the amount to the respective petitioner's bank account also, Lordship. The bank details are there. Their amount which has been transferred to their account is already been reflected in the affidavit, Lordship.
Page number?
Lordship, regarding this bank detail, copy of the bill is from running page 277 to 340. The estimated seat is 215 to 276. The bills which we have prepared, Lordship, that is Annexure 2 series, running page 215, Lordship. 215.
This amount has been transferred to your account?
Yes, yes. They have received the amount.
My lord.
No, no.
My lord, the whole process is illegal, my lord. They have conducted field survey. My lord, the assessment was done. No assessment report was given on that day, on the time of.
After
You are aggrieved by the acquisition or you are aggrieved by the compensation?
My lord, we are agreed by the whole action. Whole action.
So you should
means-
refund this amount.
My lord, they have deposited.
So you refund
My
it.
lord, they, in the account, they have taken account
You
number.
can't say that I have received the amount and then I question the whole process. You should refund this amount.
My lord, then we have to take instruction.
You take instruction,
My
you
lord.
refund this amount.
My lord.
Is the whole, why are you accepting this?
My lord,
fund?
we have
Send
not
it-
accepted. They have deposited.
But it is still in your account.
My lord.
You don't deny that.
My lord. We'll
If you are
deposit, my lord.
questioning the whole process. then
Let
you-
me have an instruction, my lord.
Yes. Mr. A.R. Sikdar, counsel for the petitioner, is permitted 3 weeks' time to complete his instructions.
My lord.
In respect of the claims made by the petitioners that they are opposed to the whole process of acquisition and of their lands. And their objection is not restricted to the quantum of compensation.
My lord, one thing, my lord, as per earlier order, they are to approach this honorable court under what provisions they have
will
not
do it, but
approached.
first you tell us what are your prayers before the court?
My lord.
You are holding on to the money,
My lord, we are not holding, they have given so much.
but it is still in your account.
My lord.
And today you are questioning the whole process.
My lord.
So far as the Assam Mala project is concerned, my lord, there are two format of forms, my lord. By it is purchased by negotiable.
No, that was not. That is.
In Assam Mala project, there are two conditions, my form of two format, my lord. If one, the parties are agreed, they are agreed, then only that negotiation takes place and executed amount, all these things are to be transferred, my lord. And for that reason, they have to agree, my lord. And some amount has to be notified between the parties.
Otherwise, how the particulars will go
Yes,
to the government?
because there no award.
Your bank account you will have to give to the authority.
They have submitted, they have
My lord,
themselves submitted.
we are laymen of the Hill district, they have taken my lord, the bank account number.
I know,
Assurance.
but they will have to, you have to give this bank account.
Well,
Why will-
the amount
Yes,
they have
also
paid,
we
my
have-
lord, totally it is
We have stated
proportionate
in
to
our
my
affidavit running.
compensation.
That's what we asked you,
My
whether
lord.
you are questioning
My
the
lord, my
process or the
Yes, we will have
quantum of
instruction.
compensation.
We will have instruction.
For landing. as per the.
The matter be listed again after a period of, let it be 4 weeks.
My lord, lord,
List on 13th of March.
lordship, lordship.
My lord.
Lordship
Leave
may keep
them.
them at a part heart law.
Not partner, why? It's only for the point of instructions. Yes, some clarification
Lordships.
as per the last order.
Yes, Lord.
Lordship, in this case, Lordship, so far, one demolition order has been passed, Lordship. Now, the petitioner filed this petition, Lordship. One of the ground is that the concerned area, it doesn't come under the jurisdiction of the GMDA, Lordship. Lordship, on last date, I placed the the master plan 2009 notification, Lordship. Therein, Lordship, this Ramcharani Moja and the villages, that is Ajara and Dharapur, are not specifically mentioned. That is the. Accordingly, I was asked to clarify the point, Lordship. Now, Lordship, today I am placing the schedule map, Lordship, of the master plan. Because how? Lordship, one arrow mark is there, handwritten. Lordship, that is Dharapur, Lordship. It comes within the schedule master plan of 2009, Lordship. That is one. And
This is what? This is a part of the GMC area.
GMDA, Lordship.
GMDA.
Yes, GMDA master plan.
And this is, notice was issued by whom?
GMDA, Lordship.
Oh. Then why don't you bring it on record?
No, in affidavit, we have already stated that this area falls under the GMDA master plan area, Lordship.
No, in view of the fact that you have been given permission to bring it on record, I think it will be better to bring it on record.
Lordship.
The master plan. Yes, Mr. Sharma.
May please your lordships. My lord, this on the last occasion, lordships, my learned friend has produced before the honorable court the Assam Gazette, lordships, and one copy also served to me, lordships. In Assam Gazette, lordships, the villages, lordships, here it is mentioned Mauja, Shilasundari Gopa, Pubbangsar, Dakshindrani, Soyani, Jalukbari, Beltola, Ulubari, and Guwahati, lordships. Now, lordships, my Mauja is Ramcharani, and also lordships, this my revenue village, this revenue circle is Ajara, lordships. I belong to 32 Dharapur Gao Panchayat, lordships. 32 Dharapur Gao Panchayat, village Dharapur, lordships, revenue village Dharapur, and lordships Mauja, it is Ramcharani. But in this lordships, whatever this document it is produced by the learned friend, lordships, here it is not mentioned this Ramcharani, lordships. Lordships, I do not come under the GMDA, lordships. Lordships, this original Patadar, lordships, that is Satyavati Kolita, lordships,
No, but this This gazette notification is for what purpose? Publication of?
Lordship, that is a gazette notification of 1986, Lordship. That is prior to master plan of 2009. Therein also Lordship will get the mention of Ramsarani Mauja, Azara, as well as Dharapur, Lordship. Now the new master plan is only an extension of the earlier master plan, Lordship. Earlier, Lordship, in terms of that master plan, Lordship, existing area.
Moza is included there.
Yes, that is in
86.
in 86 itself, that Moza was included.
Included.
Lordship, in this list, Moses, name of the Moses,
1986.
Lordship, here, whatever it is produced to me and given to me, Lordship, that Mauja Ramsarani is not mentioned, Lordship.
It is.
This is the Assam Gazette, Lordship.
Assam Gazette of published in 86.
2009.
25 September 1986.
2009.
This is
86.
that copy, Lordships, I don't have, Lordships. And also, Lordships, this
Yes.
Gao Panchayat, Lordships, still it is in existence, Lordships.
Uh,
And Lordships, I am within the 32 Gao Panchayat, Lordships. And Lordships, this original Pattadar, Satyavati Kolita, Lordships, she applied for RCC building construction, and accordingly, Lordships, in 2006, G+4 NOC was issued to her, Lordships. And within the times given, Lordship, she completed the building, Lordships. Lordship, thereafter, Lordships, I approached in 2013, Lordships, and accordingly, Lordships, these 5 cell ditch, Lordships, by 5 cell ditch, entire building was sold to me, Lordships. In the entire building sold to me, and each cell ditch, Lordships, that revenue circle is mentioned Azara, Lordships. But in this respect, Azara revenue circle is not mentioned, Lordship. Whatever documents they have produced, GMD has produced, Lordships. And Lordships, this permission was granted to me, Lordships, by Dharapur Gao Panchayat. Lordship, subsequently, when a person.
Before it was included.
Lordship, it was not included, Lordships. Still, I am
Still
paying
not
the.
included.
Lordship, still I am paying the rent to the Dharapur Gao Panchayat, Lordships.
Lordship, I also pay holding tax to GMC, but I come under the GMD authority. He pays tax to Azara Gao Panchayat, but the area comes under the GMD. So the area of GMC is something different from area under GMDA. So that he should understand first thing, Lordship. Azara is not under GMC, but Azara is under GMDA master plan area. But that is a different issue. Here, Lordship, building permission is issued by the GMC, but the area comes under GMDA. Similarly, Lordship, in his case in 2006, the building permission was issued by the concerned Gao Panchayat, but the area comes under the master plan of 1986 as well as master plan of 2009.
Now you are challenging what?
Lordship, I am challenging the order, Lordship's order, that is order passed
Page
by the
87, Lordship.
page 87, Lordships, 11/7/2023, Lordships. And here, Lordships, these two sections mentioned 87 and 88, Lordships. In respect of 88, Lordships, it is clearly mentioned
Yes.
affording opportunity to show cause, Lordships. Lordship, initially, Lordships, I was issued with a letter that whatever documents I have to produce, Lordships. And accordingly, Lordships, I have submitted the documents, Lordship, that is NOC, land documents, sale deed, etc., Lordships. Subsequently, Lordships, again, one more notice was issued, Lordships, and in that, Lordships, again, I was asked to submit some more documents.
and accordingly lordship documents as well as the reasons and also regarding section violation of section 88 lordships, I have clearly mentioned that opportunity may please be given lordships. Now lordship, I have submitted the documents, but prior to passing of this order lordships, no opportunity was given lordships. No opportunity of hearing was afforded lordships. And regarding this thing lordships, regarding these things lordships, I have a Honorable Supreme Court judgment, three bench. Three bench. Three. আগতটো নহয়, সেইটো বেলেগ। না, সেইটো বেলেগ। Lordship, three judges, honorable three judges, lordships. Here, lordship, this paragraph 48, lordships. Paragraph 48. Pertinently on the issue, a 5-judge bench of this court in court supra described in the object of observing the principles of natural justice as under. The object of observing the principles of natural justice is to ensure that every person whose
This
rights.
is only question of natural justice.
Lordships.
There is no dispute on that.
Lordships.
But no opportunity was granted to you.
No opportunity was
Why?
granted. And
Was
lordship,
it
this
granted?
paragraph 68 and 69 also clearly specify in this. Lordships.
Page 80, lordship,
80.
80. First, he was issued this notice, lordship, for the purpose of submission of NOC, approved drawing, etc., etc. He submitted, lordship. Then lordship will come to page 83. This is the so-called notice under section 87 and 88. Now, section 88 says only about reasonably so-causing. It is not specific about giving any opportunity of personal hearing or something like that. In terms of this notice, lordship, next page, lordship, page 84, he submitted his reply.
And then the
Then
impugned
the
order.
final order was passed, lordship, at page 87. So it is not that there was any violation of natural justice, lordship, or he was not given the opportunity of submitting his right, lordship.
No, I think personal hearing because you're issuing a notice for demolition.
No, first notice for submission of documents, then
But finally, the impugned notice is notice for demolition.
finally it is for demo. Now, why it will not be demolished, lordship? That is the so-called, lordship,
Right.
kindly see
It
the
not be
reference.
demolished means you want to demolish.
No,
He has to show.
the section, the language of the statement is like that. I mean, section is like that, lordship. So-cause notice issued under section 87 and 88, Guwahati Municipal Corporation Authority. So this is the so-cause.
So you ask him to demolish.
Ultimately, we issued the letter dated, I mean, order dated 1/7/2023, 11/7. Herein, the order of the GMD authority was conveyed to him.
Telling which GMDA will proceed.
Yes, lordship. So if lordship, then one order I would like to place, lordship. If lordship looks at the order dated 24/7/2023, in this case.
24/7.
Yes.
Yes.
Paragraph 11, lordship. In view of the specific drawing disclosing the setbacks, the court is inclined to observe that it would be open to the petitioner to remove the illegal construction in the setback area within 11/8/2023, which is the next returnable date, failing which it would be open to the JMDA to
No, but
proceed.
thereafter interim order was extended.
No, interim order, Lordship, may kindly come to paragraph 12.
Hmm.
What was in interim, Lordship?
No, whatever it
Accordingly,
was-
till 11/8/2023, GMDA shall not proceed with the demolition of the illegal construction made in the land of the petitioner without the leave of the court, and that there would be no bar to proceed with the proposed action after 11/8/2023. That has been specified,
Hmm.
subject to further order of this court. This portion is interim, Lordship. Otherwise, the liberty has been granted to the authority to proceed with the demolition. Lordship. So that was there. And the issue has also been decided by this order itself.
Hmm.
So in my understanding, Lordship, nothing remains in this matter to be for adjudication, Lordship. Only that point, Lordship, satisfying your Lordship as regard jurisdiction of GMDA, Lordship. That also I have placed on record. Record means place the map, Lordship. It is already there in the.
No, natural justice, you want a personal hearing.
Lordship, this paragraph 68, Lordships. Paragraph 60, the principle of odi alteram partem is the correctness of justice, ensuring that no person is condemned unheard. This principle transforms justice from a mere technical formality into a human pursuit. It safeguards against arbitrary decision-making and is needed more so in cases of unequal power dynamics. 69. And allegations of bias can only be proved if facts are established by giving an opportunity of hearing. This process requires a fair and transparent procedure in which the concerned parties are given an adequate opportunity to present their case. Such an opportunity allows the accused party or the affected individual to respond to the allegations, provide evidence, and clarify any misgivings regarding the decision-making process. Therefore, for an allegation of bias to be proved,
There are also other judgments to show to the effect that personal hearing on the given facts may be allowed where it may not be specifically mentioned.
That is one, Lordship. And secondly, Lordship, in his representation, in his reply, Lordship.
So
to
he's
the-
only asking for a personal hearing.
No, he has not,
Hmm.
Lordship. It starts from page 84.
Hmm.
This is his reply to the so-called notice, Lordship. Lordship, may kindly say not a single line has been mentioned that he needs an opportunity of personal hearing, Lordship.
80?
It starts from page 84.
84. Yes.
So this is the reply to the so-called notice, Lordship.
Hmm.
It's a long reply.
No, personal hearing, once he has explained, I think in a matter of this nature where you are asking for demolition, opportunity of being personally heard on whatever he has to say will satisfy all requirements of the rules of natural justice.
No, so far as the rule is concerned, Lordship, Rule 80, Section 88, Lordship, of Guwahati Municipal Corporation Act 1971.
Hmm.
No, GMDA Act. This is GMDA Act 1985, Lordship. The last three line I am reading, Lordship. Provided that no such order shall be made unless the owner, occupier, manager, or the person concerned has been given a reasonable opportunity to show cause why the order shall not be made. So rule is act.
The rule is there. We are not saying that your rule does not say anything, or you are denying the opportunity of hearing because in spite of the rule being there. What we are saying is that the flow of natural justice has developed to
No,
such an
Lordship,
extent
so
that
far as the-
wherever, even if it is not specified,
Yes.
unless you want to say that no, giving an opportunity of personal hearing will defeat the very purpose. What he, all he is asking for is a personal hearing.
No, why now, Lordship? So far as that may be one way of looking at the things, Lordship. But so far as the unauthorized construction is concerned,
That's what.
that is not under silence. He is nowhere he has stated that I have constructed this portion violating the building permission.
Whatever he wants to
That should have
say,
been the,
whatever he wants to
No,
say,
no,
he's
what
only
for-
asking for.
no,
ethics,
Lordship will consider. Now,
Uh.
that may be an issue, Lordship.
No. We are not putting words into the mouth of the petitioner as to what he is going to submit
Yes,
before the authority.
Yes.
His grievance, relying on the judgment, is that he wants a personal hearing. So whether he wants to challenge it, doesn't want to challenge it, that is up to him to
No,
decide.
why I'm saying, Lordship, our finding is that this portion has been constructed unauthorizedly. To that aspect, Lordship, petitioner has no reply. Now, if Lordship is satisfied that no, there is no unauthorized construction, and his part of the story should have been heard by the authority, in that situation, Lordship, violation of natural justice would have been a valid submission, Lordship. In this case, Lordship, it will not hold any water, Lordship, because of the fact that
There
it
is
is
no denial.
it may be clearly observed from the inspection report also, wherein the petitioner was also present. It is there in the affidavit that yes, this part has been unauthorizedly constructed.
Lordships, this already I have placed a Supreme Court judgment. Lordship,
Lordship, under what circumstances that order was passed, Lordship, I am not aware.
Which order?
Lordships, this is Municipal Corporation Ludhiana versus Inderjit Singh and another, Lordships. Here, this paragraph 15 and 7, I have make a note, Lordships. This, the notice was vague and lacked any description of the property. The corporation did not disclose how much area of the property was the subject matter of unauthorized construction. Since a sanction plan existed, it was obligatory for the authority to categorically state.
On facts, these are not applicable to you because according to you, he was never under GMC or GMD authority.
Lordships,
You had taken permission from the Gaon Panchayat and you have constructed.
Lordships. And that Panchayat Act is still in force, Lordships.
Whatever it may be. So you, if your case is purely on the ground of natural justice is one aspect.
Lordships.
And the other is that no, GMDA does not have any authority. Then this matter will require further hearing. What do you say?
Lordship, this, that I may be given an opportunity to place my matter before the GMD authority, Lordships. Otherwise,
First, you
Lordships,
satisfy us that it is outside the jurisdiction of the GMD.
Lordship, it is outside the jurisdiction of the GMDA, Lordship.
All right.
I do not come under the GMDA, Lordships, because I took the permission from the Gaon Panchayat. Still, I am paying the revenue to the Gaon Panchayat, Lordships, and also with my Mouja is Ramsarane, and whichever this.
All right, we'll go for further hearing on 12th of February.
Lordships.